Thanks very much and good morning. Avsheni, Khuyamore Dumelang, and Macheloni, Molweni Sanbonan. Welcome to the third committee meeting of the Impeachment Committee. We know each other, so there will not be introductions of the members today. So welcome and apologies for the 4-minute delay. We're sorting out the seating arrangements. There are 2 seats just to my left that we had requested so that the presenters can sit there. So that's what caused the 4-minute delay. But thanks very much and welcome to the meeting. All right. So before we start the meeting, I want to wish the national team well for their game tomorrow morning, 3 o'clock in the morning. I'm told that we are sleeping at 7 tonight so that we can wake up to support Phala Phala tomorrow against South Korea. So we wish the boys well for the game tomorrow. And the agenda of the meeting is flighted. I'll now ask the committee secretary to just go through the apologies. And after the apologies, we'll then go to introduce the team that's supporting the committee so that the members are aware of the team that's supporting the committee. Secretary, Honorable Sir.
Chair, I was wondering if it wouldn't be appropriate, given the gravitas of the issue we're dealing with, to have a time of prayer meditation like we normally do when we open parliamentary sitting. And I'd ask you to consider that time of prayer meditation before we commence, given the gravity of the issues we're dealing with. Thank you.
All right. Thanks very much, Honorable Salt. I will take that as from henceforth, when we open the meeting, we open with time for silent prayer and meditation. If I could just ask the members and everyone in the room to just observe a moment of silent prayer and meditation before we start the meeting. Thank you very much. We now move to apologies.
Good morning, Chair. Good morning, members, and good morning to everyone present in the meeting. Chair, in terms of apologies, we have the first one come from Ms. N. Sharif of the DA. She's attending Social Development Committee. And then we have an apology from Mr. Vessels of the Freedom Front Plus. He is traveling on an international study tour. And then we have an apology from Mr. Kwankwa of the UDM. He is on sick leave. And we also have an apology from Ms. Khachau of the DA, also on sick leave. And we have an apology from Mr. Mutama. He is running a little bit late. And Chair, whilst I'm at that, and the last one, Chair, would be from Dr. Maimane. He has prior engagements. And whilst I'm at that, Chair, perhaps safe to indicate that there has been some changes in the committee. The first one relates to the membership of the MK party. Mr. Mutama, who was an alternate member, has now been appointed a full-time member. And Mr. Gama, who was a full-time member, has now been appointed an alternate. And also, Chairperson, Build One South Africa did not have an alternate. It was only Dr. Maimane. Now, Ms. Hlazo Webster has also been has been appointed as an alternate to Dr. Maimane. So those are the changes that are in the committee. Thank you very much, Chairperson.
Thank you very much. Can we accept the apologies? Honorable Ngola?
Yes, we, for the record, want to accept the apologies and also accept the new changes that have been made in the 2 political parties and welcome those who have just joined us. Thank you so much.
Thanks very much. I'll now ask the committee secretary to introduce the team that's supporting this committee. And as you are introduced, if you are in the room, if you could just please stand so that the members can see who is supporting this committee, is fully supported, the committee.
Thank you, Chair, once again. Chairperson, if I can start with the lead project manager in absentia, who has submitted an apology. It's our section manager, Ms. Natalia Pochard. However, in her absence, we have project manager, Dr. Tulisile Kanyaza Twalo, who's well known to members, Dr. Twalo. That is Dr. Twalo. She is assisted by Mr. Mkaji, Tulisile Mkaji, and Mr. Ludumo Sishuba. So when Dr. Twalo Kanyaza is not here, the other 2 unit managers or one of the other 2 managers will be here. Chairperson, in terms of the committee secretaries, Tembinkosi speaking is the first committee secretary. We have 2 other committee secretaries, Ms. Nandi Pam Makligwana, if you can stand up. Thank you very much, Ms. Makligwana. We also have Ms. Koliswa Pasiamdende. She is following the proceedings on the on social media platforms, Chairperson. And amongst us, Chairperson, we're also blessed to have a graduate trainee who's seated right next to Ms. Isaacs. That is Ms. Melissa Kaba, an LLB graduate from the University of Stellenbosch. She is allocated to the Office of the Secretariat, Ms. Kaba. Thank you, Chairperson. And legal advisors, Chairperson, we have 2 that are located in the committee, Ms. Swain Isaacs. Thank you. And we also, in absentia, have Mr. Michael Prince, and they are both working under the guidance of the Acting Chief Legal Advisor, Advocate Jenkins. Thank you, Advocate Jenkins. And Chairperson, content advisors, we have Advocate Armanel. There she is at the back, Advocate Nell, and she's working together with 3 other content advisors, Ms. Sibusiso Kumede, Dr. Anthea van der Berg, and Mr. Pedelani Dlomo. Chairperson, you know that today is Wednesday, so some of these colleagues are attending to other committees. And honorable members, we have 2 committee assistants. Ms. Priscilla Mahlati mainly deals with members' transport. I'm sure she would have been in contact with some of the members, but she's currently attending a portfolio committee of transport. And we also have Ms. Stella Mkosana at the back. Thank you very much. And Chairperson, from the researchers, we have Mr. Mziwokolo Dano, who is not with us today, but in his absence, there's Mr. Dustin Davids, and then there's Mr. Zibusi Sohlongwane. Those are the three researchers, Chair. And lastly, Chairperson, we have a Principal Communication Officer well known to the members of this Parliament, Mrs. Faith Ndenze. Thank you, Faith. Chairperson, that will be it in terms of your support staff. Thank you very much.
Thanks very much. As you can tell, this is a very important committee, and it's well supported. The Parliament has done its best to ensure that the committee is well supported, both in terms of content advisors, researchers, and secretaries, to ensure that the work that we do here is adequate, fully compliant with the laws and the rules of the National Assembly. I see Honourable Swart has got a question.
Yeah, could we have that list circulated to the members as well, of all the support staff, to all of us, if that's possible? Thank you. And their contact details, if possible. Thank you.
We will circulate the list with contact details. Honourable Maute.
No, thank you, Chair. While we appreciate the support that Parliament has given this committee, can, while you circulate that list, also indicate their roles? What is their roles in this committee, so that we're all clear what we're dealing with? The big support staff, I must say, probably the same number as the committee members itself. So maybe we can be assigned to one. But thank you, Chair. Just give us the roles. Thank you.
The roles will come just to indicate to members that not all the support staff will be in attendance. It's the same thing that you'll have whether in a team where you have those that are sitting on the bench and others supporting in the background. So not everyone will come to the committee, but there will always be adequate support in the committee. We'll circulate that list, their roles, and also if there are other people that will come in to support the team, will come in. Thanks. All right, thanks. We now move to the third item, which is formal correspondence that the committee has received since its inception on the 1st of June. To date, I know that there's a correspondence that we received last night from the EFF. It will not be part of this presentation, but we know that we'll deal with that issue when we deal with the issue of the evidence leaders, the issue that was raised by the EFF last night. So if I can ask Melissa to take us through the correspondence that the committee has received since the 1st of June 2026.
Thank you, Chair. Good morning, members. Good morning to everyone in attendance. I will be going through the correspondence received by the committee till date from the 2nd of June. On the 2nd of June, a letter from the EFF was addressed to the Speaker and the Chairperson of the committee. It was a formal request by the EFF to ensure that the appointment of evidence leaders for the impeachment inquiry is controlled by the committee itself, to ensure the process is credible, independent, has no political interference, and is transparent. On the 3rd of June, a response letter was received from the committee's chairperson to EFF leader, Mr. Julius Malema. The chairperson acknowledges Honourable Malema's concerns, and he promises to consider them via engagement with the Speaker of the National Assembly and stakeholders. The chairperson reassures that the impeachment process will be handled properly and fairly. On the 3rd of June as well, a letter from the President's attorneys was addressed to the Speaker of the National Assembly and the Chairperson of the Impeachment Committee. The President's attorneys informed Parliament that while preparations for the impeachment process can continue, they asked that the formal inquiry be paused until a court review is decided. They argued that this avoids unfair prejudice and wasted effort if the court later rules in the President's favour. They asked that the Speaker respond by the 8th. On the 8th of June, a follow-up letter was received from the President's attorneys addressed to the Chairperson. The President's attorneys asked the Chairperson directly to pause the impeachment hearing until the court review is finalised, while allowing preparations to continue. They note that the Speaker has passed decision to the Chairperson and that the court process is being... My apologies. On the 9th of June, a response by the Chairperson through the State Attorney to the President's attorneys was received. The Chairperson rejects the President's request to pause the formal impeachment inquiry and confirms that the committee will continue with its work. Only a court order can stop the process, as the committee is legally required to proceed under the Constitution and are bound by the Constitutional Court decision in Economic Freedom Fighters and another versus Speaker of the National Assembly and others. On the 10th of June, a letter from the Speaker of the National Assembly was addressed to the Chairperson. The Speaker informs the Chairperson that the Rules Committee has developed draft procedures for how the impeachment inquiry should be conducted. She is formally sending these draft procedures and political party submissions to the Section 89 Impeachment Committee to consider when carrying out its duties. On the 15th of June, a letter from the Chairperson to the members of the committee was received, raised the President's urgent application, which was an interdict. Members are informed that the President has filed an urgent court application to stop the impeachment committee and its proceedings. The Chairperson has requested legal advice on what this means and what the committee should do next. The meeting was scheduled to be held on the 18th of June to brief members on the legal opinion and decide on a way forward. On the 15th of June, a letter was received from the ACDP and was addressed to the Speaker of the National Assembly and the Chairperson. The ACDP opposes the President's court application to stop the impeachment inquiry, saying it would delay the process for many months, would delay accountability and weaken Parliament's role, as well as prevent Parliament from carrying out its constitutional duty. They also call for an urgent committee meeting to deal with the matter quickly. On the 15th of June, a letter from Action SA was addressed to the Speaker and the Chairperson. Action SA strongly opposes the President's interdict and urges Parliament to fight it legally. They argue that the President is trying to delay or avoid accountability, and Parliament must not allow this. They question the President's claim for urgency and emphasize that Parliament has a constitutional duty to continue the impeachment process. They proceed to call for the committee to meet urgently and continue its work without delay. On the 18th of June, a letter from the Chairperson was addressed to the Speaker of the National Assembly. The committee resolves to oppose the President's interdict and will continue its work unless a court says otherwise. The committee asked the Speaker to support this decision to ensure a unified position from Parliament and given its importance and urgency. On the 20th of June, the response was received from the Speaker of the National Assembly to the Chairperson. The Speaker confirms that she will not join the committee in formally opposing the President's interdict. Instead, she has filed a notice to abide with an explanatory affidavit. She explains that Parliament must continue with the impeachment process unless a court decides otherwise. The matter is now properly the responsibility of the Impeachment Committee, which must act independently within its mandate. She believes her approach and the committee stance are not in conflict, but rather reflect their different roles. On the 23rd of June, last night, a letter from the EFF addressed to the Chairperson was received. The EFF is urgently requesting the committee to include an agenda item in the next meeting for the inclusion of the appointment of a forensic investigator and exchange control specialist on the committee agenda. The EFF argues that the case that the committee is dealing with is complex as it includes financial transactions, cross-border fund flows, and regulatory issues. Thus, the committee requires specialized technical support to properly discharge its constitutional and oversight responsibilities. I thank you.
Thank you very much, Melissa. So, honorable members, this is the correspondence that has been sent to the committee and also responded by ourselves and myself as the chairperson. I don't, if there's anyone that maybe have sent the correspondence that's not highlighted here or has got a question, this is the time for question if anyone has got a question or any input. Honorable Mkhalakis.
Thank you, Chair. Chair, this is just an observation and it relates to the Speaker's response. In my opinion, there's a lot that I think many people get wrong. The Speaker's independence is important, but that relates very much to the review application and the merits of this impeachment. And I agree there that the Speaker should absolutely be impartial. However, when it comes to the interdict application, it is a question of the Speaker taking a position to back Parliament versus backing the President. And she cannot, under those circumstances, be impartial. She must always, by definition, choose the side of Parliament. And we must make that point. With regard to the merits of the impeachment and the review process, the Speaker must be impartial. But by definition, the Speaker must always protect Parliament against anyone else who wants to stop Parliament from doing its job. I want to make that point. The argument that the Speaker says that she needs to stand neutral in a conflict between Parliament and the President does not hold water. She cannot be neutral. She must defend Parliament. So I do want to, from my side, express again my disappointment at the Speaker taking the stance that she did. I do think that she should have acted in line with the wishes of the committee. I don't think the committee has locus standi to fight it. We can't pay the bill. It has to go through Parliament. And the Speaker should have backed Parliament and ourselves in this matter. And I do think that impartiality when it comes to defending Parliament is maybe too convenient an excuse. And I do just want to very strongly, again, express my disappointment, if I can put it mildly, at the Speaker's stance. Thank you, Chair.
Thank you very much, Honorable Mkhalakis, Honorable Ngola and Dagmo and Kireko.
Thank you very much, Chair. Chair, I think having read the response of the Speaker in relation to the appointment of evidence leaders, I think also well captured in the draft that was sent to us by the Secretariat in relation to the detailed rules. It still puts the committee as the center of the appointment of the evidence leaders, in that we suggest we may later be able to approve or disapprove. We may also have to fire or unfire in terms of the draft that was sent to us. Nevertheless, Chair, I think it is important to note that soliciting any services goes through a particular administrative mechanism, which is through procuring and all that, which is something that we are not involved in. Chair, I think we fully agree with you in your response to the President that we are under no legal obligation as we speak to not proceed with the work of the Impeachment Committee, most particularly to the fact that we are dealing with issues that are preliminary stages towards the inquiry. And we know, Chair, that is public information now that the interdict application is set to sit on the 15th and 16th of July, which we are part of. So we have not forgotten that we are part of a litigation as this committee. Nevertheless, we're under no obligation to stop, particularly to the fact that we are now dealing with preliminary stages of our committee. Lastly, Chair, I fully agree with the EFF on the appointment of the forensic investigator. Maybe we can even think, Chair, around even soliciting a data analyst or something. was sometimes we get it difficult to pick up that the statements that we have received from witnesses, for example, do have material discrepancies, do have serious lies and all those things. So I believe, Chair, that if we solicit the services of those two, we can be able to effectively do our work. Thank you so much, Chair.
Thanks very much, Honorable Ngola. So I indicate...
On a procedural point, I'm sorry to...
Yeah.
Yes, I'm actually lost. I don't know what we're doing.
Yes,
so
it is
I'm
a matter of
extremely
order.
lost.
I'll come to you, Honorable Dagmo. You are the next one. I'll come to you now. Yes, it is.
So I was asking, what are we following so that we don't get lost? And it's not only us who are following this proceeding. There are people out there following the proceeding. So if we touch this one, touch that one, touch that, then the next things are lost. So I would suggest that we deal with the first correspondence and then members express themselves. And then when we've exhausted that one, we go to the next one, like that. Because Honorable Leader of the DA, Mahalagis, dealt with something else. And then Honorable Ngola, when he came in, he dealt with something else. So I thought we were going to deal with what Mahalagis started with and close it and then go to the next one so that we don't get lost. We're all at one.
Right. Thanks very much. So what I was expecting from the members is just let's call it a general reflection on the correspondence. So the correspondence has happened. So most of the issues that are raised in the correspondence are either leading up to the interdict application on the 15th, on the issues relating to the last correspondence. What I had said was that we are going to deal with that matter when we deal with the evidence leaders. So the item that deals with the appointment of the evidence leaders, the issues of the investigators and so forth, we are going to deal with it on that one. So the correspondence of the 2nd of June and the correspondence of the 12th of the 23rd, it's already dealt with in the agenda insofar as the evidence leaders are concerned. The issues as it relates to, which was the general reflection. So I was expecting a general reflection in terms of just the correspondence, because there's been some reflection on the decisions that have been taken. So it was supposed to be a short one, not for us to get deep into the agenda. So that's how I had allowed the hand. So if you are going to reflect on an item that's on the agenda, whether it's the detailed roles, it's the evidence leaders, investigators, and so forth, don't reflect. But if you want to just reflect in terms of the general correspondence that the committee has received, how it has dealt with it, this is the moment. Honorable Dagmo.
No, thank you, Chair. I think that was part of the reason I requested to speak, was to get exactly what item we are on. I think a similar point to Honorable Malema. So I understand we're on a point called general reflections on the correspondence. So just in that regard, I wonder if the committee could just put up that table on the correspondence, because just to say that, firstly, in regard to the point that Honorable Mikalakis is making, I think it's clear from the correspondence presented there that the Speaker at an early stage in this process indicated to the committee that it is this committee that and in her correspondence as well that was tabled at the last meeting to the President's attorneys, that the Impeachment Committee is the committee seized with this particular matter. So I strongly disagree with the view advanced by Honourable Mikalakis, because the Speaker had indicated to the Impeachment Committee, and in her notice to abide, she also, if one looks at what she has submitted to the court, indicates very clearly that the notice to abide is not indicating agreement with the President's interdict. So I think that what we're dealing with, Chair, and we're going to have to reflect on, is that, and as this correspondence reflects, is that the Impeachment Committee, the matter was actually in correspondence from the Speaker referred to the Impeachment Committee. She, as the Speaker, has, on the basis of her argument, decided to abide, but also filed that particular affidavit. That's the first point. And then generally on correspondence, I note, Chair, that, and I think if we can just go up, but there was an initial response that you as the chairperson gave, and your words, I think if we can just, where the chairperson of the committee says that we would rejects. Sorry, it's actually the 9th of June, where you are quoted in this letter as saying that you reject. Now, my understanding is that we as a committee had not met yet. And so I just want to ask then, in terms of you as our chair rejecting that request, because what I understand the President was asking for is not to stop the preparatory work, but to receive a commitment about the actual commencement of the hearings. But it's quoted here that you then rejected that. So I want to ask, on what basis, on what legal advice, because there was previously in the last meeting we had a reference to the state attorney. So I just want to ask, Chair, in regard to your rejecting that request before the committee had actually met, whether you received advice on that, and then linked to that issue is the actual opinion that we then received, and which I think is a matter flowing from this item of correspondence. Who in particular requested the opinion that we then received? Because we'd all remember that there was, the opinion basically talked about opposition, but then it had a one line about the other option which we as an impeachment committee had, which was to abide. So I would just like clarity on that. And then, as I understand it, we are now dealing with general responses to the correspondence. Thanks.
Thanks very much. I'll take the the hands of Honorable Dureko and then Honorable Papane. I see Honorable Swart and Witama and Honorable Malema.
Thank you, Chair. Greetings to members. Chair, mine is on the issue that has been raised with regard to the Speaker, whereby the Honorable Member is saying that the Speaker has acted against Parliament. Chair, I believe that when we're engaging on this matter, we're given two legal opinions with regard to the matter, of which the first one, as the committee, was to oppose, and the second one was to abide by the court. And during our meeting at the time, there were three options. The first one was saying that we abide by the court. The second one was saying that we should oppose the matter. And then the DA, during that meeting, they also raised the issue of you as the chairperson engaging the Speaker and ensuring that at least you reach consensus on what needs to be happening. But because the approach that we took at the time was an approach whereby the political party were raising their issues, we never went to the extent of checking whether the majority, in terms of the 50+1 of the members of the committee, were in agreement with that or not. But because of the time constraint, we then allowed the process to take place. So it cannot be correct that when the Speaker has then legally acted on the matter, where she has used her independence and ensure that she protect both the interests of the committee, the community, and her office on the matter, we then deem to see that thing as a wrong action. It can be. The Speaker decision that she has taken, I personally believe that is the right decision because she allows the process of court to take place with an affidavit on the matter as to with the affidavit to that decision that she has taken. And I believe that in doing so, it shows that she doesn't want to take a side. She just wants to allow the law to take place. So she cannot be crucified on that decision, whereby it was part of the legal opinion that we also had as this committee. So it's wrong, Chair, to pin that matter on the Speaker. The Speaker's office have then made their own determination on the matter based on the merits and the advice that her office deemed to be fine and assisting for us. So we cannot blame her for that process. Thank you, Chair.
Honorable Papane.
Thank you very much, Honorable Chairperson. Good morning to you and my colleagues and everyone in this room. I want to echo the same sentiments as my colleague. As a committee, we were presented with two options, to abide or to oppose. And as a committee, we took our own route to oppose. So I would want to believe that the Speaker also had her own legal opinion that she followed. So the responsibility is for this committee to do its work, to follow the necessary processes. So we have made our choice and let's stick to it as a committee. And also to agree with Honorable Dureko here that on that day of the meeting, not all of us had an opportunity to express ourselves with regard to the decision that was taken. It was put to political parties, as we all know. So blaming the Speaker for taking her own decision is something else. I don't think it should arise in this meeting. We have taken our own decision, which was not influenced by anyone, not by the Speaker or anyone. We agree to that, to the decision that we have taken. Then on the issue of the forensic investigator, I want to agree with my colleagues. We are not...
Papane, I asked that that particular matter,
Okay.
It's on the agenda. Let's not reflect on it.
Okay. So I submit, Honorable Chairperson, that it was our decision to oppose, not influenced by anyone. Thank you.
Thanks. Honorable Swart.
Chair, thank you. Firstly, I want to thank you for your very prompt response to the letter from the ACDP. I'm not sure if we've received a response from Speaker yet, but we highlighted there our desire that both you and the Speaker should oppose the interim application, setting out very cogent legal reasons why that should be done. And Chair, I'd also want to commend you for acceding to our request for an early meeting. We requested for Wednesday, but Thursday was given that we needed to get senior legal counsel opinion. That was quite understandable. And to commend the staff and the legal team for getting that senior counsel's opinion, which was very compelling regarding the tests for an urgent application. We still are disappointed with the Speaker's decision, given the fact that this is the institution of Parliament where an interdict has been sought, and we made it very cogent, and it's not pointed out in the summary there, that the application, and I put that question as a lawyer, to the senior counsel, that should this interim application for an interdict succeed, it's not only binding to the hearing on the 2nd of September, but any appeal which should arise from a party that is unhappy with the review application could then file an appeal to the Constitutional Court, which could take months and years. So the impact, and I don't think that was set out in the Speaker's affidavit, and that would have been required in an opposition. And you pointed that out, Chair, in your affidavit. So I want to express my disappointment with the Speaker's decision in not opposing this and in not protecting the institution of Parliament, given this is an impeachment hearing, which is very severe. It's setting legal precedents going forward. So, Chair, again, to commend from your side. And thank you for your very quick response.
Thanks very much, Honorable Ngutama.
Thanks, Chair. And also let me express my appreciation of the work that you have done as per the committee decision. Chair, I think that with regard to the Speaker's attitude, this committee must take a much more stronger attitude towards her abdication of her responsibility. She has the institutional leadership to protect the work of this Parliament, and the highest court has ruled that this parliament must do its work. And the speaker can't throw her hands out and say that let the process take its course. She has to take a position to essentially protect the institution. It's because she is the head of this institution. Chair, I think that more than expressing a disappointment, we need to find a way to persuade her to do what is correct. I don't know, Chair, if we might ask you to express once more the feeling of the House that she can't abandon that process. She must take a much more stronger position. Thank you, Chair.
Thanks very much, Honorable Malema. Then I'll respond to Honorable Dagma.
No, thanks, Chairperson. Firstly, let's appreciate the fact that you carried the mandate of the committee and did so very well. It is incorrect to want to create an impression that a decision was taken outside a democratic process, because we're all sitting here. And when a process was outlined, we're all here. And those who wanted to oppose, they could have said no. But also, is disingenuous, but also a denial that I no longer have majority. So this illusion that if we had voted, we're going to win, is the old mentality. So people have not come to reality that it will not have resulted in something else. Because we all spoke in one language, including members of the DA, who said the speaker must be the one who carries this responsibility. That's where there was a difference. But that we are going to oppose, it was a principle. So when you say majority, as if you're living under President Mbeki's parliament, wake up to the reality, smell the coffee. And that's how you're going to start dealing with issues in a more sober and objective way and lobby others, not only those who are in the GNU. Because the situation this parliament finds itself in, it suggests that there must be permanent interaction between parties. It's not automatic that we are this number of GNU. GNU is not the same party. And therefore to think because we are more in GNU automatically will overrule them. You're going to be very disappointed. You're going to be very disappointed, and then you're going to come here and speak things that are not real. We can go back and vote if that's what you want, but it's too late. So we took a right decision, supported by the majority, and you did the good work. And I like the giraffe view of this committee. You can see we're being set up for a trap that no, leave it. The speaker will deal with it. They knew what they were going to do. They were setting up South Africans. Leave it. The speaker will deal with it. When we say no, let's leave it to the speaker. Speaker was going to do exactly what she did and will not be represented. I hope South Africans can see their dishonesty, that even when they were taken below the necessary numbers, they're still continuing with that conduct of calling a swimming pool a fire pool. That conduct is still continuing. And I hope some of you comrades don't want to go down with that image of opposing the obvious. So the speaker acted wrongfully by not opposing. The president is challenging the panel report of parliament. The speaker's advice, legal advice, was only one option: oppose. There was no two options. Speaker can't rely on the legal advice of our committee. She went to get her own legal advice, said oppose. Then the legal advice told her what she didn't want to hear. Then she says when she does interviews, which is dishonest, the legal advice said, I also have an option to abide. Her advice doesn't have that option. It is your advice which has got that option. It's our advice, and she has no right to use our advice. They were not advising her. She got her own advice, and the advice said, go to court. So as a committee, we need to take a very strong view that we're disappointed by what the speaker did, because her duty is to protect parliament. I was asking our legal team, what legal avenues do we have on this speaker? Because she just abandoned her responsibility, which is to defend parliament as another arm of the state. No, she says, hi, you can do anything you want, I will abide. And exactly the letter I wrote to her, I said to her, you cannot choose a legal team that is going to represent parliament because you voted no against this panel report that is now being challenged. So you're conflicted. Your conscience must tell you you're conflicted. You said this report must be thrown away. Now there is a legal process that says it must be thrown away. And then you appoint lawyers. Even when you oppose, you appoint lawyers to go and oppose something that you said it must be thrown away. Leave that process to parties in parliament the same way the speaker before left the process to the parties to submit the names of people who can serve in the panel report. So I support those who say we need to send a message to the speaker that as a committee charged with this responsibility, we're disappointed because we're a committee of parliament, and as a head of parliament, she's got the responsibility to protect all of us. We can't be seen to be going different direction. Worse, when her legal opinion says you have only one option, and that option is to defend, is to object. Thanks, Chair.
Thanks very much. Last end, Honorable Ngobeni, then we respond and then we can move forward. I think we have properly ventilated the reflection.
Thank you very much, Chair. And also, good morning to all of the members. I think, colleagues, it is important for us, for our foundations to be correct. I do want to augment what has already been said, particularly by Honorable Malema, that we are not in this committee to protect, now we're protecting the speaker, or we are defending the speaker, or defending the president. I think ultimately what we are here to do is to have the process of this impeachment process unfold as the Constitutional Court has directed, to say that we must ventilate the issues, we must act on behalf of the people of South Africa as we are parliament, and we must ensure that the president can clear his name if that is what his wish has been. He has always said that he wants, to represent himself and say he has done nothing wrong. And so we are not here to be in the battle of legal opinions. We are here to ensure that this process unfolds fairly, it unfolds impartially, and that the members of this committee must have an open mind around what is happening. We have no conclusive evidence whatsoever as to what has transpired in this matter. Our job is to ensure that we can ventilate the matters that are important in this regard, make sure that the people who are implicated or the persons of interest can represent themselves and appear before this committee, including the president himself or his representation, however way that is going to unfold. We are not here, honestly, to present a divided view to the South African people. We must act as one, as I've heard a previous speaker say, as this committee. And so I'm getting the sense that, you've got the one side that is defending or even speaking on behalf of the speaker, and then the other side that is saying we must, the president must do something else. We are not here to do that. And I'm hoping that this process of this particular committee is going to unfold in that way for us to discharge our duties in order to be able to get to the bottom of what actually happened at Phala Phala. I'm hoping that is the posture that we are going to take is going to be precisely that particular kind of posture. Thank you very much.
Thanks very much. Just to say that the institution of parliament will support the committee in court. So as in ensuring that the legal team behind the committee is fully supported. So every aspect is taken care in that respect. Just to put that members at ease that from the institution side, the committee is supported. And I've said that we need to focus on the things that are in our control. Those outside of the room will reflect on them, but we allow them to be. Just two questions that were asked, I think it was direct to me, Honorable Dagmo. So in the response that was given on the 9th of June, I relied on Rule 158(2)B of the Rules of the National Assembly that gives powers to the chairperson to act on any matter. And I also consulted with the Constitutional and Legal Services in terms of giving that response. So the rules were, because the letter itself was written on the 8th, and it had given myself as a chairperson by midday of the 10th to respond to the letter of the president. So I checked with the team to say that we can use 158(2)B in that response. So that's the rule that we apply to respond to the president. Insofar as your second question, in seeking the opinion, as soon as the urgent interdict landed on Friday, the 12th, I think it was filed 16:32. That's the exact time that it was filed. I think I got the interdict around 5 o'clock on the day because I'm the second respondent. I also started interacting with the CLSO to say, all right, what are the options available to me as the second respondent? So I did then get to say that at first it was a conversation of whether we need to get our own legal opinion as a committee or myself as a chairperson, and we settled on that matter. It was on Monday, if I remember, Monday the 15th, that we then resolved on getting our own legal opinion. So that was a conversation between myself as a second respondent and also as a chairperson to then seek a legal opinion that then, as you remember, on the 15th of June at around 12 p.m. a notice came to the committee to indicate that I've sought legal opinion on this matter and that the meeting will be convened soon, the meeting which was convened on the 18th. So we followed every step of the way since the first correspondence we received. I was in conversation with the legal advisors appointed to the committee, and they guided me through the process. So thanks very much. Honorable Hlophe.
Thank you very much, Chairperson. It is very clear to me that the Speaker totally misconstrued her role in this matter. The real question going forward is we need to take a decision as this committee as to what exactly to do in the light of the fact that the Speaker totally misconstrued her role. If anything, the legal advice that was given to her, it was that she must oppose the interdict application. She chose to ignore that advice. The real question is going forward, what are we agreeing upon? As this committee going forward, we must agree as to what are we going to do about the Speaker who has derelicted her duty. Her duty is to uphold the Constitution and to protect Parliament. She has failed dismally in that regard. So we need to agree what are we going to do going forward in relation to the conduct of the Speaker. She clearly lacks objectivity in this. Thank you.
Thanks very much, Honorable Hlophe. Just to say that the Speaker is not a member of this committee. So the Speaker accounts to the Assembly. So if there's a body that has to hold the Speaker accountable, it's not this committee. It is the National Assembly. So if you want to bring any motion to hold the Speaker accountable, it has to be done through the National Assembly. The committee itself cannot call the Speaker to come and account to it. She's accountable to the National Assembly, and political parties are within their rights to call for that accountability of the Speaker in the National Assembly. So let's not take powers to ourselves that does not belong here. I see the legal advisor Jenkins wants to share something. Thanks.
Chairperson, good morning, honourable members. Maybe just to assist Chairperson, the Constitutional Court placed the report of the independent panel before this committee. It was quite an interesting judgment because usually the Constitutional Court or any court will refer away from these processes within Parliament and say, Parliament, deal with it in your process. But in this instance, it said, look, it must go back to the committee. It must skip. In other words, we're not asking the Speaker to refer the committee or suggesting it. We're putting it before the Impeachment Committee, and we're saying to the Impeachment Committee, I think it's around paragraph 140, proceed unless the report of the independent panel is set aside. So in that circumstances, the power is lying with this committee to proceed. So for the Speaker to take legal advice on how she should respond to the interdict, and let me first say this, Chairperson, the Speaker responded to the President's letter as set out in the papers of the President, that she received the letter and then said it's in the committee's hands now. It's in the Rule 169, I think it is, indicates that the committee is in charge of its own internal procedures. So from that respect, she said to the President legal team, that is where the committee's power lies, that is where the report is.
Chair.
So is in that...
Chair, on a point of order, please. You've ruled on this matter. We're ready to move to the next point. Now you're bringing the Speaker's ambassador here to come and defend the Speaker.
Right.
No, this is wrong.
No.
Jenkins is constantly wrong and always misleading the Speaker. That's why we lose so many cases as Parliament.
Honorable Mount. All right. Dagmo, please put your hand down. I've seen your hand. Put it down. Thank you, Jenkins. Thanks for the clarity. Thanks. Honorable members, we'll now proceed to the point of order.
Chair, I think let's just agree on a procedure. Some points of order are not more equal than others. I'm raising a point of order that I'm asking you as the chair of this committee to rule on whether members of this committee can actually abuse and insult officials of this parliament. We've seen it happening in committees where without any evidence the Secretary of Parliament is abused. If we're going to allow points of order to stop an official of this parliament talking, rather respond at the end. If we're going to allow that at the beginning of this process, we are going to run into problems. I'm asking for a ruling that allow the official to complete what he wanted to say. How can we allow this?
Right. Honorable members, I see your hands. I see them. Please put them down. I've seen them. I need to rule on this one. So, Honorable Dagmo, that's why when Honorable Mauto was going that direction, I asked her to, so that we can proceed. And members, I've seen your hands. So I don't want us to take time debating this particular point. I hear the feeling, I hear what is said. I would like to proceed with the meeting now. So the point is taken. Now, I've conferred with him. We conferred with him. Let's proceed with the agenda of the day. So we now move to the next item, which is the consideration of the detailed rules. So just to say, honorable members, before I ask the legal advisor to take us through. So this will be the terms of reference. I know that in the agenda it says the detailed rules. It will be the terms of reference. To take us through will be Suen. So the process in terms of how we arrived here is that it started in the subcommittee on rules. That Advocate Breitenbach started working on the detailed rules. Political parties represented in the subcommittee on rules had already, or they gave inputs as was circulated to members. You have seen the inputs of political parties. It then went to the rules committee. The rules committee is the one that referred these terms to form the framework, or these rules to form the framework of our terms of reference. So what's going to happen this morning is that Suen is going to take us through at a high level the detailed rules as contained, as it pertains to also the comments, the initial comments that were submitted by political parties to the subcommittee on rules. And then we'll have general reflections on the detailed rules. So take this as the first draft. So this is not the final draft. We don't have to adopt these rules today. We'll have general reflection on the detailed rules, and then we'll give the other political parties and everyone else who is a member of this committee, because now it's no longer in the subcommittee. We cannot take everything that comes from the subcommittee to be the rules or the terms of reference of this committee. Once we're done with the general reflection, we'll then give the members of this committee 10 working days to then consider these terms of reference, come back, and then we have a final draft that we can then adopt. So I didn't want them to then just present to the committee the outcome of the subcommittee and say, as the impeachment committee adopt these rules. It will not have been a fair process, and also in line with the rules of the National Assembly. Honorable Strat,
Chair, I'm just trying to understand the process now, because in terms of the rules of the National Assembly, rules must be adopted by the Rules Committee. Have we got the jurisdiction to accept the rules, which I would think we should? Some of them should be an implied power, but you said it's not going back to the Rules Committee. So are we then going to accept the rules here, and then it goes to the National Assembly to be accepted as rules of the equal go forward? I just needed to understand that, and you might want to come back to respond to that.
All right, thanks. So these are not rules, will be terms of reference of the committee. So before the development, the reason we gave the report as it is, it was envisaged at the time when it was presented in the subcommittee on rules that they will then be accepted as the rules of the National Assembly. That will have necessitated an additional amendment to Rule 129M5. so which was not accepted by the subcommittee on rules. So now it will be for the committee to then accept its terms of reference. So it will no longer be rules, it will be the terms of reference. And then I think once we have that, we can then move it to make it an order so that the next committee, so in the way that you'll see the way that the rules are written, or let's call them the terms of reference, just to avoid the terminology, because if we call it the rules, it means it will go to the National Assembly. The terms of reference are written in a manner in that the next committee that will come after us will not have to start from scratch. That's why we'll need to make it an order so that the next committee can immediately, the committee that will come after us will then start and don't have to develop its own terms of reference. So that's the point that I wanted to raise. Can we now allow us to take us through the terms of reference of the draft terms of reference? So this is the first draft, honorable members. Let's take it as the first draft. It will take us through the first draft, and then we will then give general reflection and then send it to the members in 10 days to give us their comments on this. Thanks very much, Suen.
Thank you, Chairperson, and greetings to the members and the guests present. Chairperson, the committee secretary provided members with a copy of the detailed rules. The title is Detailed Rules Governing Section 89 Inquiries by the Impeachment Committee into motions by members of the National Assembly calling for the removal of the President from office in terms of Section 89(1) of the Constitution of the Republic of South Africa. Chairperson, as you advised or you informed the committee that this is a very comprehensive set of rules, the debate was as to whether this should be incorporated into the National Assembly rules, but it has subsequently been referred to this committee to form maybe the basis for the terms of reference, and members will deliberate as to what should be included into the terms of reference. As members will see that this is a very long document and it's very comprehensive, so I will merely do a very high-level presentation highlighting the different areas.
Just sort of disrupt. Honorable members, I'm just asking Honorable Swart to stand in for me for 5 minutes I'm responding to a call of only 5 minutes to stand in as the chair. Thanks.
Thank you. So as I've indicated, this document is 40 pages long, and I would just go to the key areas and highlight the different headings as to what areas they covered. So one of the matters is the first is the definitions, and that sets out the various definitions referred to into the detailed rules. The one relates to the general Section 89 rules, which is on page 1, the last definition, and that has since been updated by the National Assembly yesterday to bring the Section 89 rules in line with the Constitutional Court order. So that reference will have to be updated. And then on page 2 and so forth, it goes into all the necessary definitions for the purpose of this document. Section 2 of this document deals with the legal framework, and it sets out the various constitutional provisions that are relevant for the purpose of this process. That is Section 56, Section 57, Section 59, and then Section 89, which deals with the removal of the president. There's specific definitions further down related. So the next part of this, members, is on page 5, which is the general Section 89 rules. These are the rules that are currently adopted by the National Assembly, and they're already in part of the National Assembly rules. So that this whole section merely restates the Section 89 rules. And as I indicated, those were amended yesterday, so this may need to be updated if members want to incorporate that in their terms of reference. So from page 5 onwards, it's merely restating all the relevant rules for this process. And I don't intend to go through those rules because members would have had sight of them yesterday. So that takes us to page 9 of the document. And then on page 10, we then get into the detailed rules. So some of these rules refer to existing National Assembly rules. The person who drafted this did so in a manner that created a one-stop reference for this process. So there is a lot of cross-reference to existing rules, and obviously members will have to consider whether this is the format they would want to go with or whether we should remove them or not. So the first section there deals with composition, appointment, and terms of office of members of Impeachment Committee. So that is covered in Rule 154, 155, 156, and 163 of the Assembly rules. And as we are now past that process, this committee has been appointed. So we will have to consider whether we retain that or not. The next section deals with meetings and quorums of Impeachment Committee. That also is covered in the current National Assembly rules. Section 5, or the next paragraph, deals with decision-making by the Impeachment Committee. That is covered in Rule 129 of the General Section 89 rules and also Rule 158(2)(d) of the Assembly rules. I will point members to paragraph 5.2, which says voting in the Impeachment Committee must occur openly unless the committee, pursuant to a request by the chairperson or a member, otherwise resolves. So this proposes voting maybe by secret ballot. This is something that members need to consider, and as to whether it can be incorporated in terms of reference, as this process should be properly regulated by rules of the National Assembly. There's also a constitutional court case which determines when voting by secret ballot can take place, and we need to decide whether that would be practical for a committee to have voting by secret ballot, and if so, what are the guidelines that will determine when that occurs. The next paragraph deals with the chairperson of the Impeachment Committee. That also, the process to appoint the chair has passed, and the chair is now been elected. Paragraph 6.3 deals with the chairperson or acting chairperson, and it sets out the roles of the chairperson as per National Assembly Rule 1582. And it goes into detail as to what the role of the chairperson, what powers he has, and this obviously is related to existing rules. So the powers are not necessarily new, but it's something that we are familiar with as to what the role of chairpersons of committees are. Specifically in subparagraph 6.3.3.3.1, it allows the chairperson to issue directions from time to time aimed at ensuring the orderly and proper conduct of the proceedings of the committee. So that's just an important point that empowers the chairperson to deal with matters that may arise during the committee process. The next paragraph or the next section deals with the committee secretary and the role of the committee secretary. The committee secretary has already been appointed, and that usually occurs according to normal parliament internal administrative processes. The rules do indicate a different process here, but we will need to determine whether that is still relevant. The rules are important in respect to the duties of the committee secretary, because the committee secretary has very specific duties that he has to do. For instance, he has to publish notices, he has to ensure the correspondence to the president, he reaches the president. So those are maybe certain aspects we could consider incorporating, and the committee secretary is also required to keep all the records of the proceedings. In paragraph chapter 8 or section 8, we deal with the chief evidence leader and assistant evidence leaders. This also sets a very detailed process on the appointment of evidence leaders, and it sets out their roles, their functions, and what needs to be determined is whether we retain this or whether some of this can be incorporated into an agreement with the evidence leader, because it goes into great detail as to what the evidence leader can do and what they cannot do, including how witness statements must be drafted, notices to implicated people. So there may be aspects that may be retained, or if the members wish to retain it as it is, or consider having a separate agreement that is entered into by the Secretary of Parliament with the evidence leaders. The next section deals with the President's representative. Rule 129M allows the President to be assisted by a legal practitioner or another expert of their choice. And this section sets out the various procedures and what can happen with the legal representative when the President decides to terminate that mandate. What are the steps? What are the processes? It also requires the President to appoint an address for service of documents. And then it deals with instances where the President opts not to have legal representation, and just the general rules as to what conduct and is expected of the legal representative. The next one is the section 10, which is the general call for witnesses, documents, and real evidence. This is an important section because this deals with public involvement in the process. This allows for the committee to put out a general call to the public to provide any evidence, if they have documents, if they are witnesses to the matter, to contact the committee secretary. And obviously, the evidence leaders will consult with the persons who have identified themselves and determine whether that evidence is relevant to the committee process. Section 11 deals with applications to impeachment committee, and that sets out the process as to when there may be an application brought to the committee and the process as to how it's decided. The next section, meetings of the impeachment committee, that sets out in detail how meetings may be held. I think of importance would be clause 12.3.2, and that deals with alternate members, as those rules propose that they do not have speaking or voting rights when the member is there. So I think the issue of them not speaking is something that the members would consider and whether they retain that or not. 12.4 deals with closed meetings. The National Assembly rules allow for meetings to be closed under certain circumstances, and that rules, the proposed rules also draw on that and allow for meetings to be closed when there is a justification in terms of our constitutional framework. The next section, 13, deals with media coverage of the impeachment meetings of the impeachment committee, and this is in line with the Powers and Privileges Act. It merely restates that, and it sets out that those meetings may be broadcast on the Parliament channel and also on YouTube or any other social media channel. Next, section 14 deals with conduct during or in relation to proceedings of the impeachment committee. This sets out conduct for members and witnesses and all those participating. This is in line with the National Assembly rules, and it is the conduct expected of all members and those who participate in parliamentary proceedings. The next section is dealing with opening remarks and sets out how this may be done, with the allowing for the chairperson to make an opening remark, and the evidence leaders may also be allowed to make opening remarks. It also provides for time allocations for these opening statements. Section 16 deals with very detailed procedures for witnesses and goes into great detail. I think of importance is the issue of the president choosing to testify. That is something that the committee members would want to consider as to the president having an election to testify or not, and his rights as to whether he may do so compared to the committee's right to ask him to testify. The rest of the paragraphs from 16 on page 24 deals with the protection of witnesses who take the oath and goes on into details. The next page on 25 deals with issues where the evidence leader brings witnesses and the time allocation for that. Suppose that the evidence leader has 2 hours and each member is allowed 30 minutes to question the witness, unless the chairperson determines otherwise. And then time allocation is an important issue that the committee will have to deliberate on. The next paragraph deals with witnesses testifying under compulsion. Those are witnesses who may be summoned or brought from prison to testify at the inquiry if their evidence is relevant. And this also follows the existing legal framework to summons people. On page 26, we deal with the president's representatives' witnesses, and also it's similar to the other processes as to time allocation and as to members, the time allocated to members as well. The next paragraph on the 1610 henceforth deals with the president, and it says if the president elects to testify and there is a representative, the president may elect that their evidence is presented by the president's representative, in which the paragraph 16.5 and 16.9.1 of the section 89 rules will apply. So we just need to, this is where the president decides to testify and the process as to what happens when the president testifies. So the next page, on page 27, the heading is witnesses presented by members of the Impeachment Committee and evidence by the public. And this particular provision, 16.12, says any member of the Impeachment Committee may apply in writing for leave to present a witness or documentary or real evidence on a matter relevant to the impeachment motion. And it sets out the process as to which a member of the Impeachment Committee may do so, apply for a witness to be heard at the committee. And hence what it sets out the entire process as to what may be done when the chairperson grants the application, the process when the chairperson refuses such an application, and it specifically 16.12 allows the Impeachment Committee to consider an application where the chairperson refuses to grant the application of a member who wants to bring a witness to the committee. So the committee will retain that power to make a decision where the chairperson refuses. The next section is 15.16 of the Powers and Privileges Act, and this deals with evidence where people agree to bring evidence before the committee. Page 29 deals with witness summons or brought from prison, and again, it sets out the process in the Powers and Privileges Act in great detail. On page 30, we deal with claims of legal, professional privilege and confidentiality. This deals with documents that are confidential and the process that the committee must follow where a person requests that the documents be treated confidentially. The committee will still be able to consider those documents, but they may not necessarily release it to the public. But that's a decision that the committee will make after considering the application brought by the person who requests that the documents be made confidential. And then that goes on, the entire process goes on, and then we deal with, on page 32, witnesses who during their testimony implicate others. And just firstly, whenever a person is implicated, if the evidence leader or the president's representative knows that the person is going to be implicated, a notice must be given to that person ahead of time that they will be implicated. But this deals with instances where a person, without informing the legal representatives, just implicates someone. So this sets out the process to ensure that there's protection for people who are implicated. And then 17 is an important section which deals with evidence that may be presented to or relied on by the Impeachment Committee. And it goes into detail about the rules of evidence and what could be allowed. It deals with hearsay evidence in terms of the Law of Evidence Amendment Act, and those are the tests as to when hearsay evidence may be admissible, and if the committee will be able to consider hearsay evidence under certain circumstances. Also deals with documentary evidence. It deals with expert evidence, which the committee may consider, and the rules governing expert evidence, what needs to be done prior to that evidence being admitted. In 17.6 of note is that impeachment committee may not draw an inference adverse to the president solely from a decision of the president's representative not to present witnesses or a decision by the president not to testify. So that's a point of note that members may want to consider. On page 34, we deal with the recording and transcripts of meetings of impeachment committee in section 18, and that just requires that there be a transcription service and that where possible that a transcript be provided by the next day. In section 19, we deal with written and oral submissions. And I think of note is paragraph 19.1. The members need to consider this matter. After the impeachment committee has concluded its hearings and received all evidence on which it will base its finding and recommendation, the committee secretary must publish in a manner set out in paragraph 10.2 of the section 89 inquiry rules a general call by the committee for applications of members of the public or other interested parties, example, juristic persons or associations without juristic personality, to leave to make submissions to the committee. So this is basically when all the evidence is heard, and I think before the closing arguments, so to speak, this allows for the public to make submissions on the process. So that is something that the committee needs to consider. And it goes on to the process as to when, how these requests or applications will be deliberated on, and the entire process dealing with that evidence. That brings us to page 36, which deals with the committee deliberations and decisions. And this is also quite an important part of this terms of reference. It says, after the conclusion of the oral submissions, the impeachment committee must meet to deliberate and decide, and that's 20.1.1, whether or not the charges against the president in the impeachment motion is established on the balance of probabilities by the evidence and the reasons for the finding, and 20.1.2, if the committee decides that the charges is so established, whether to recommend to the assembly that the president be removed from office and the reasons for the recommendation. And then it goes into further detail about each, the different types of charges, but that is an important point, is that the standard would be a balance of probability. So that deals with the committee deliberations and decisions. And then 21 deals with the committee report to the National Assembly, and the committee secretary there has a responsibility to facilitate the drafting of the report, and it sets out the process as to how members input on the draft. It just is process driven, and but it allows for for deliberations on the report. So the final version is something that the committee agrees to and is presented to the Assembly. And then 22 just deals with general matters related to the inquiry. And then 23 deals with the commencement, publication, and citation of these rules. These rules, obviously, this was intended to be rules. So if it is in terms of reference, then once the committee agrees to the terms of reference after all the consultations, then that will take effect from the date it's agreed to. Chairperson, do you want me to go to the evidence leader direct?
No, let's deal with this, then we'll deal with that separately. Thank you very much, Sven. And members, so these are the detailed terms of reference, so that from henceforth we get the terminology correct. So these are detailed terms of reference, and we must thank the team that has taken this process thus far. And now I'll invite members just for an initial reflection. So in making your reflection, this will also help other political parties and other members of the committee to think of aspects that they need to consider when they give their written comments, so that we move closer to a final draft. So I'll recognize hands for initial reflection, and then we will then move to the next one. So I've noted the hands of Honorable Zungula, Honorable Ngobeni, Honorable Swart, Honorable Litchfield Shabalala, Honorable Nola, Honorable Mahlaule. Is there anyone else? Honorable Adams, Daniel, Nitama. Was your end up? All right. All right. Thanks very much. I've noted the last two hands. I've noted it. Thanks very much, Honorable Zungula.
Ndikubulise sihlalo, ndibulise onke amalungu akhoyo nabo bonke abantu abakhoyo kulo mhlangano. Ndifuna sihlalo uqala ndiveske ndingene ngqo emxholweni. When you read section 16.1, I think it is underlined fourth there. It says if the president chooses to testify, that is the first and most important issue that we need to address. It cannot be left to the president to choose to testify or not. If he's summoned by the committee, and I think that is what the committee will do, it will summon him, then he has no choice whether to come or not to come. He must come if he's summoned. The rules can't give him the leeway to decide what to do. That's the first thing. So that is consistent with 16.10, 16.11, and 16.11.1. So anyway that it says elects or may, it must be clear that if he's summoned, and we must change the may to must. And then on 17.6, that the committee must not make an inference by the decision of the president not to come. If he's summoned and he refuses to come for whatever reason, we must make an inference because he has a legal obligation to account. So those are the few issues I just wanted to raise, Chair. Thank you.
Thank you very much. Honorable Litchfield Shabala.
Thank you. I think it is the same area. Luckily, I'm sitting next to the evidence, the legal representative here, so I have the copy. The president elects to testify, and there is a president's representative. The president may elect that their representative is represented by the president's representative. I seek clarity here. So he can say, I'm coming, but my representative is the one that will give evidence on my behalf. Is that what we are saying? So it's about him. So I seek that clarity. And then Zungula has covered me on the may, if he will respond. He may, it's in English, may says I have a leeway to say I can't. So we should start using words of must and should. Yeah.
Thanks very much, Honorable Nola.
Thank you, Chair. Generally, I think the detailed terms of reference, the draft, covers a lot of ground in terms of the work that we are supposed to undertake. And as a person who have served both in the Section 194 committee and the ad hoc committee, I think there is synergy on how those two committees have governed their own internal process. And what I think generally, there may be those particular issues. Generally, they cover how this work has been conducted with precision, undoubtedly, in both the former committees. Going to what Honorable Zungula is saying, I see that there's some of these provisions in the 16th paragraph, they are highlighted in a different color. For example, what Honorable Zungula is saying, any witness presented by the president, or if the president chooses to testify, they are highlighted. So want to check with them if there is any significance attached to the highlighting in respect to what Honorable Zungula is talking about. Other things are just minor issues on definitions. Day, I think they made a mistake. They're saying the policy day or policy holiday instead of public holiday. I think it's a minor thing. Also on there's this issue of referral. I think it's on 14.4.1. The issue of referring to the chair and the members strictly as honorable. I think the rules provide a different approach on that we must refer to members in respectful terms. So I'm not sure if we are not tampering with what the rules are saying, but if it's not a major thing that may cause us problems, it's fine, we can continue with it. There's no issue around it. Also, Chair, I think it's a drafting issue. This one also is not a procedural matter. In paragraph 12.2, they go to an extent of making an example of an online meeting that e.g. Ms. Teams. I think for purposes of terms of reference, we shouldn't go to that extent. We may say the chair is going to call a physical meeting. The meeting may be called online. The meeting may be called physical and partly online, or we just say hybrid, not to go to an extent of making an example about Ms. Teams. We may not use Ms. Teams. Since I've been here, Parliament has never used Ms. Teams anyway. So I'm not saying Ms. Teams must be changed. I'm saying the reference of Ms. Teams in its entirely is not necessary. Thank you very much, Chair.
Thanks very much, Honorable Nola. Just to indicate, in case someone is going, you are coming. In case someone asks in terms of the highlight, so the highlight came out from when the SC who drafted the terms of reference was briefing me and the support team. These were some of the questions that we had, that we said, no, the committee will definitely, if I have questions on them, the committee will definitely have questions on them. So you'll see that some of these, Zungula, you won't come for the second time now. Wait for your turn. So just to indicate that.
The clarity from what you are saying, Chair.
You'll ask the clarity at the end once everyone has spoken. Honorable Ngobet.
Thank you, Chair. I'm just chuckling because Honorable Hola saying Miss Teams, that we must not use Miss Teams. I don't know if gender-wise we want to be using Miss Teams, but anyway. Look, I think from our perspective, Chair, we had looked at the spirit of these terms of reference, draft terms of reference. I think the clause by clause nature of our submission, I want to get clarity as to whether you will afford us the opportunity to send those in writing. But I wanted just to make a commentary on the terms of reference as they are now. The first is that we mentioned at the beginning of the meeting that this is a highly important precedence-setting process. We stated this earlier in the meeting, and I think the spirit of that should be carried throughout this process. And so I think the first one that we want to deal with, I think we want to echo the previous speakers around the wording of if the president chooses. I don't think that we are at that juncture. There is no choice. Much as we are able to summon every other witness to come through, we should be able to do exactly the same thing. And we also want clarity with regards to, and I think we discussed this in an earlier meeting, around the president having representation as opposed to himself appearing personally. So I think if we can clarify that, it will be important. I also want to submit that we should really refine and consider the submission of the 30 minutes per member. I'm not sure how practical that will be. If I can give an example, the ANC has 9 members on this committee. That essentially gives them almost 4.5 hours to deliberate with one witness, but we're only giving the evidence leader 2 hours. I don't know how proportionate that sounds. We might want to reflect on that. That means we'll be here for a very long time. So I think we must just discuss that. I also want to assert, Chair, that we perhaps have a conversation around timelines for us to finalize these terms of references, so that we can, create an expectation as to how our work is going to unfold, so that it's not open-ended. I think members have expressed that concern. So perhaps let me get into our thoughts around this, around these terms of reference. We've got a couple of points. I will not elaborate on each and every one of them extensively, but I want to say that firstly, we looked at the chairperson's powers. We believe that there's too much power in the chair's hands. It's excessive in our view. We understand that there's previous committees, and this is guided by what has previously happened in Parliament and the rules that currently exist. However, we are in a different juncture at the moment with regards to the work that we have to undertake in this committee. And so we might want to relook the discretionary powers that the chairperson may have. And here we're looking at evidence, witnesses. If the chair's discretion says witnesses can be pardoned and not appear, we don't believe that should be the case. We believe that there must be concurrence with the committee with regards to certain instances. And also the second part is with regards to the access of the public. I think transparency is key with regards to how these processes are going to happen. And so we really need to refine the public and media access to these proceedings in terms of how the terms of reference are written. So that it's very clear that when we say that proceedings will be closed, we really should be very clear around the demonstrable risk to things like national security, the safety of witnesses, etc., etc. We believe that should be expressly written within these terms of reference. And then, of course, the next part is the importance of the appointment of evidence leaders. We believe that the evidence leader really needs to be somebody who firstly has got experience with leading proceedings like this, and that person should be absolutely impartial, and that we believe that we should strengthen the criteria for them for disclosures with regards to the evidence leader in terms of any potential conflicts of interest that they may have, and that the criteria for the appointment of such evidence leaders need to be transparent. We believe that that really should be expressed in these terms of reference. And I'm relying on the fact that we have said that we want this process is precedent setting, so that the next chair who may be sitting in the position that you are sitting, and that members of a committee such as this do not have to start from ground zero. And then, of course, the removal of evidence leaders. I believe that in that process, that it should also be very well expressed as to how an evidence leader may be removed. And I think I want to end on the public participation. Of course, there's more, but I think these are key. I want to end on the public participation. We believe that the public should be able to participate in these proceedings throughout, and not really at the end only. And we can discuss how that is going to transpire. But there is a sense in which there's great public investment and interest in the work that we're doing, and we don't believe that the public should only have access at the end. I think that should sufficiently deal with our broad, spirit of how we deliberated on these terms of reference so far. But I hope that we will have the opportunity, Chair, to submit them as they are, and you synthesize them for the rest of the committee, so we can finalize the draft, the final draft for the committee. Thank you.
Thanks very much, Honorable Ngobeni, and that's the way we're going to move. So we are giving general reflection now. Members of the committee will have 10 working days to give written comments. Also, so this opportunity now is to help other members to think of maybe other issues that they will not have thought about. So that's, you'll still have an opportunity to give your written comments. Honorable Mashaul.
Thanks very much, Chairperson, and greetings to yourself and honorable members. We have few points to make, but we will not, in line with what you just said now. I wanted to make and sponsor a proposal, which I think honorable members will receive well. You know, this document is, maybe let me start from the spirit of the Concord judgment of inclusivity, that every political party must be included. And that's why we're 31 in this committee. All of us are here except the PAC and the GOOD, because their members serve in the executive. In that spirit of inclusivity, and considering that this document comes from the sub-rules and did not get ventilated in the rules committee, the sub-rules composition is very small. It doesn't cover all political parties, especially smaller political parties. And if it's not ventilated in the rules committee, it comes here, and we think we'll do justice by just reflecting today. We may not do justice to that. In that spirit of inclusivity, I would suggest that, Chair, you have already made a proposal of 10 days. The proposal in line with that would be, let's give political parties to go and reflect on this document. It may seem obvious that you flag one thing that is obvious to you now, but there may be other issues that you as and when we go, you realize that you missed and you did not reflect. And this is a legal document that needs political parties to go and get legal advices from their political party. So in that spirit of inclusivity, let's allow political parties, especially those that do not serve in the sub-rules, to go and reflect, and we be fair to them and all of that. For 10 days or more, I don't know. I did not want to talk about the evidence leaders, but you allowed Honorable Ngobeni to reflect. The same proposal I want to sponsor, Chair, that let's allow political parties to go and apply their mind on who do they want to be evidence leader, and open it up to a time frame which will allow.
Honorable Mashaul.
Yes.
The next item speaks to that, on the evidence leaders. So if I can just ask that if any of the members are going to reflect on the evidence leaders, we have an item that speaks to evidence leaders, then let's park the conversation on the evidence leaders on that. To that.
Thanks, Chair. I do want you to note that I made a disclaimer that I'm only speaking on it because you allowed Honorable Ngobeni, but I have no problems with that. Thanks.
Thanks very much, Honorable Swart.
In the queue, Chair, as I presume I was after. But anyway, I'm going to just comment broadly.
Just so that in the future, you also, in terms of how I will proceed, I try not to have the voice coming from the same corner, need to be able to move on both sides.
I totally understand that, but I think you mentioned a list, you said.
No, it was the people that I had recognized, I had taken down their names. Okay. It was not the order of speaking.
Okay. Okay, so it's not the order of speaking. That's okay. Now we've got that clear. Thank you, Chair. And firstly, may I express appreciation from our side for the drafting of these detailed rules. And again, I think it's important for those parties that were not part of the sub-rules, like the ACDP, to engage on the process. I just wanted generally to appreciate and emphasize that what we are dealing with here is investigative. It's very objectively investigative. So my question relates to the evidence leader gathering the evidence, and it ties in with the Honourable Maotwe request for that type of investigators that are going to be investigating very complex foreign currency issues, and whether the rules sufficiently cover that. And that's something that we'll need to look into, because I noticed the gathering and inviting submissions, but there doesn't seem to be a space for a particular instruction by an evidence leader or a member of the committee or you as chair to the committee to engage with an investigator to go deeper into an issue which comes up and to prepare us. Secondly, I wanted to just understand and tie in with the issue, and it's a double-edged sword with the speaking time, because obviously if one applies a proportional limit, then it can be limiting to parties. But we do need to engage around that 30 minutes and how it would be equitable in understanding if 30 members are using 30 minutes, how long that's going to be. Thirdly, Chair, I also wanted to just reflect on the 1610 if the president elects to testify. And I think that we're going to need to really reflect on that, because that seems to contradict the committee's powers to subpoena any witness. Should the president, and I would really think he would want to come and explain certain issues, but should he choose not to elect, then clearly my understanding is we have the powers to subpoena. So you don't want to have conflicting rules. And I think that is where we would need to be very careful how we formulate this, that formulation does not then excuse the president from any subpoena powers that this committee might need to make use of. And we trust that wouldn't be necessary, but we can't have a conflict there legally. But we will engage. Thank you for the invitation.
Thank you very much, Honorable Daniels.
Thank you so much, Honorable Chairperson. Greetings, colleagues. Chairperson, I just want to state that procedural fairness, and that's my intention that I want us to consider. It's not a courtesy to the president. It protects this committee because it's a condition on which the committee's eventual findings will stand or fall. Now, I also want to welcome the presentation that was made around the details of the rules that governs us. I want to know if we are going to keep Section 89 threshold in the rules and need clarity or consideration rather, because Section 89(1) speaks to the removal of the president, and that's why we are here. Now, the rules, do the rules require the charges to be formulated against a specific Section 89.1? Does it, based on those grounds that we rely on, with the serious threshold of that ground stated, which speaks to serious violation of the Constitution, serious misconduct, or inability to perform the functions of office, so that the inquiry is anchored to the constitutional test and not to a general assessment of conduct? Is there a clear statement that the committee applies the Section 89(1) grounds as the Constitution frames them, and that it does not lower or broaden those thresholds? Because I'm reflecting on the submissions made by relevant parties, which I welcome. I've seen the synergy in those submissions made by all the parties around the drafts and the proposals of the rules that should guide us. But my question purely is just, I'm going to reserve my further questions on the evidence leaders until we get to that point. But to keep the threshold of Section 89 in the rules is where my interest lies in to protect this committee. Thank you.
Thanks very much. Honorable Adams.
Thank you, Chairperson, and good morning, colleagues. Chairperson, we only have a few very minor concerns. Can I just use Section 12.1? Meetings of the Impeachment Committee will be held on the dates and times determined by the Chairperson, the committee, the evidence leaders, and the President's representative. Now, Chairperson, if we consider the fact that the President might be doing everything in his power to avoid this committee, we can't need the President's input into our dates, because the President's behavior at the moment, it suggests that he might want to delay this. So we feel that needs to be looked at. And then 16.1, Chairperson, considering the fact that this committee has the power to compel witnesses, we must remember that His Excellency the President is still only a citizen of this country, and we can't leave a backdoor open for him to want to avoid or enable him to avoid accountability to this committee. Again, considering the fact that the President is going to extremes to avoid this committee. And then finally, Chairperson, thank you for the presentation. It's very thorough. It's also indicative of the amount of work ahead of us, but can the Chairperson perhaps disclose to this committee who the SC is that drafted those papers? And there's a reason for that question. The SC might be the same person that opposed the EFF and ATM High Court application. And if that is the case, then, there's more than a suspicion that it might be a conflict of interest, because you can't be arguing against an application in court on the one hand and then be drafting papers for the same issue on the other. That just doesn't make sense. Thank you very much, Chairperson.
Thank you very much, Honorable Papan.
Thank you very much, Honorable Chairperson, and thanks for the opportunity. Honorable Chairperson, I want to agree with Honorable Mahlaule with regard to this document, that it is a thick document and we cannot exhaust it today. Opportunity should be given to political parties, especially those who are not sitting in the subcommittee on rules, for them to go through the documents and make their own inputs as suggested. And then when going through the documents, you might notice that some of the matters are a repetition of what is currently contained in the 9th editions of our rules, like the functions of the chairperson. They are captured in the rules, so there's no need to repeat those within the terms of references. I was just citing an example. Then also, as per the timeframes that you have suggested, Honorable Chair, I know you are going to wrap up on that matter. I think it will maybe be sufficient for political parties to make their statements. Then the other matter of the evidence leader will be able to ventilate on it as and when that time arrives. Then as for the forensic investigator, I think we would support that, Honorable Chair, because we don't have that those expertise to deal with these matters. Thank you very much.
Thanks very much, Honorable Malema.
Thanks, Chair. In the draft, there is firstly, let's welcome the draft of terms of reference. It's a section that deals with evidence leader there, and then, like you said, we'll deal with it as an agenda item. We also feel that the issue of forensic investigators must also be in the terms of reference, and the exchange control aspect also be in the terms of. I fully agree that with your suggestion that we must refer the matter to political parties and they must come back within 10 days with their input. I don't agree that we need to go back because the smaller parties must also have an input, thing like that. We draft our own terms of, it's not rules. The first thing I wanted to correct was the heading there was actually misleading. It's not rules, it's terms of reference. And we do our own terms. This committee does its own terms of reference and adopt its own terms of reference. So, but I welcome the fact that you are saying 10 days, let's go and look at this, and then we will make our own input. It also allows us to also bring the legal experts into it, our own party legal experts, to look at it and advise us to what is acceptable and what is not acceptable. It's not acceptable that the president may not attend. The president is going to attend. Is the main person here. And then the other issue is that even if he comes, this legal team, even if he comes with this legal team, it will sit at the back, and then he will have to speak. And if there's a need for him to consult this legal team, he will get that permission from you. Ask for the permission from the chair. We adjourn for 10 minutes or whatever period we agree on for him to take some consultation with his legal team. But we're not going to have a lawyer there giving us a headache. Yeah. So that's how we don't hold the president accountable through legal representative because we have not elected a legal representative, and that there is no evidence that is going to be given on a hybrid or virtual. Every evidence is going to be presented in a physical meeting of any witness. We have to come and sit and give that evidence. And I think this matter is very sensitive, and South Africans have got interest in it. So also through you, Chair, working with your support staff, we need to engage the Speaker to allocate a permanent room for this committee. We don't want to come here and then we're told today we're not here, we're running that way. And then when we run that way, we're squeezed. There's no space and all of that. A conducive room must be created where it can even be captured in the terms of reference that impeachment committee will take place at what room and so on. So it becomes a venue of the impeachment committee. Thanks, Chair. We'll make our input, but generally we're there. We're almost agreeing with most of this who spoke.
All right. I'll come to you, Ngita. Zigzag. Dagmo.
So you said Dagmo.
Honorable Minister Dagmo.
Thank you, Chair. Chair, the first issue I'd like to raise is that, as you've clarified, we're dealing here with guidelines. But I think what's important to note is that it would be when the Rules Committee looks at, the further amendments, that there's a reference in the Rules Committee. Whenever this Impeachment Committee adopts those guidelines, it would be useful that at a certain point the rules would refer to the impeachment guidelines as adopted, because it's a separate, we all agree it's, but I think it's useful the rules themselves refer to that, because then it gives it a particular status to deal with. The issue of Section 59 of the referring to public involvement in legislative and other processes, at the moment, the guidelines refer to that clause. But I do think, and other colleagues have raised that, is that it would be important for the guidelines to give effect to exactly what we mean by public involvement in other processes. I think we must just flesh that out. I think that's important. Members have raised critical importance of this. I think in terms of the time allocation, Chair, I'm not sure whether you agree, but I think we learned a lesson that we cannot, as this committee, be boxed in to a political party. We are 31 individual members here. All of us have the right to express our views. And I think we should avoid a situation where we, in terms of these guidelines, are not boxed into having to speak as a bloc. We are appointed here as individuals. Yes, we all come from political parties, but I just think we should be cautious from being led down an unnecessary path in future. And then I think Clause 56 of the Constitution is very, very clear when it comes to the issue of attendance. It's very clear that the National Assembly or any of its committees may summon any person. I think that's the starting point, so that in terms of what concerns that people have raised around that issue, we should be guided by the Constitution in terms of our powers to summons who we need to appear. So I think let's give precedence to the Constitution in terms of that particular issue. And then my understanding is that when we get to the next item, as per your ruling, I'm not sure whether the guidelines should, list every single person that we're going to employ. Clearly, chief evidence lead, assistants, there might well be other kind of experts. So I think when we get to that, I'll discuss what we need to include in the guidelines and what we don't need to. Thank you.
Thank you very much, Honorable Ndekama.
Thank you, Chair. Chair, the first point is that follow up on Honorable Adams' question as to whether the drafters may be conflicted. So I think today we must get the response to that. Who are these drafters, so that matter of raising suspicion is resolved. Then, Chair, I was very concerned about that. Clause 16, which is voluntarist, so the president might choose to. So now I'm glad that we have remedied that by saying that we have this opportunity to make written submissions, which will certainly make, and to remedy that the serious defect. The president cannot have an option of whether to appear before this committee or not. This committee is set up precisely to try to deal with matters related to his conduct. How can he then choose not to appear before this committee? But we appreciate the opportunity to make the written submission. Thanks.
Thanks. Honorable Mashatsa.
Thank you, Chairperson. Thank you, Chairperson. I'll touch on the issue of transparency, but I only have 2 points. I have been covered by my colleague. On the issue of confidentiality. Now, confidentiality rules are too open-ended, and they may permit overclassification on politically relevant material. Please look into that, because the draft does not express a presumption in favor of public disclosure with a narrow and justified exception. So please look into that. Thank you very much.
Honorable Mutambi.
Thank you, Chair. I think I want to support those that we say let's take this terms of reference to our various political parties so that we can have more time. This 10-day working day period that you are proposing, I think it can assist a great deal. Also on the issue of 1610, that's a major concern to everyone. The judge will attest to me also that in terms of Section 35 of the Constitution, a witness to a tribunal can elect, not that he won't come by, but there's a requirement in terms of the law. There's also case law to that effect in this South African case to say then a person can elect. But I think this is the matter you must seek legal opinion on that, because it's there. I should think the drafter will have to talk to that. The reason why they put elect is solely on that basis. But it's a matter that is, and when we go through the rules, then we'll be able to look at that. There's also case law to that effect. That's a matter that I wanted to. I think the drafter, when they did that, they were informed by that provision. Thank you for the opportunity.
Thank you very much. Honorable Hlophe is the last speaker. You still want clarity, Honorable Zungula? All right. Honorable Hlophe, and then Honorable Zungula will ask his question, and then I'll respond to the only question in terms of the drafters. I thought I'd responded to it when I started the item, but I'll respond again.
Right. Thank you so much, Chair. For purposes of this discussion, I'm going to make 3 assumptions. Firstly, that the president has nothing to hide. Secondly, that he is aware that he must account and he does not mind accounting public. Thirdly, the president has given public statements, a public account relating to the whole incident of Phala Phala. Some of the questions that we are going to ask here are peculiarly within the knowledge of the president. Nobody else can give answers. And we're entitled as this committee to test the version that he has already given public against the evidence that he will give you. And the issues of credibility may come in. So in my view, he has no option but to come and testify and tell the nation what happened in Phala Phala. Furthermore, I agree entirely with the submission that was made by Honorable Zungula and also entirely with the submission made by Honorable Malema. The president must come and testify. He does not have an option. He must come and tell us, take the nation into account relating to the events that happened in Phala Phala. He may not refuse to do that. If there is a case to answer and he refuses to testify, an adverse inference can be drawn against. That's how law operates. If there is a case that he must answer and you elect not to answer, an adverse inference can be drawn against. And he may not, therefore, testify through an agent or an appointee. He himself must come and testify and will cross-examine on those aspects that we consider relevant. That is my side.
All right. Clarity of Honorable Zungula, and then I'll just clarify on the drafters and so forth.
Yeah, Chair, we know that Breitenbach, the SC, was the one who drafted these terms of reference. No, not this one. SC, I said SC. Yeah. And it is the same SC that went to court on the EFF and ATM case in Phala Phala, representing Parliament against our application that led to this process. So the clarity-seeking question is that, do you not view it as a conflict of interest in that regard by utilizing someone who was clearly against this process to be the one now that is giving life to the process by drafting the rules that will guide the process?
All right, thanks very much. So when I started this item, I indicated that this framework or this guideline emanates from the Subcommittee on Rules and the Rules Committee. That process is led by the Speaker. So Advocate Breitenbach SC is a legal representative of the Speaker. So now the draft is with us. It's up to us to change whatever we want to change. If there's an aspect that we think this aspect is not correct and needs to be strengthened, it needs to be so. But this guideline is referred to us from the Rules Committee to say, as an impeachment committee, here is a guideline that you can use. If we feel as a committee that everything that's written is not applicable, then in your written submission, please indicate as such. But for me, I do not see a conflict because we are operating from a referral from a process that was led by the Speaker. The advocate is a representative of the Speaker in that respect. So we can accept the text. The text is in front of us. The time that we will give political parties, you'll then reflect. If you disagree with 8.1.5, then it's your right. Now that document, it's a draft of the committee. You can then accept it or not accept it. Let's not try to litigate matters that shouldn't be here. If there was an issue, I think that issue did not arise in the Subcommittee on Rules. it not arise in the Rules Committee. And we are working with a referral from the Rules Committee. I'll give Suen if there are a few aspects that you want to quickly clarify before we move to the next item, but there's an agreement in terms of the time to give political parties to give written comments. Suen?
Thank you, Chairperson. I just think there were two issues of questions of clarity. That was with regard to 16.10. If the president elects to testify and is a president's representative, the president may elect that their evidence is presented by the president's representative, in which event paragraph 16.5 applies. So basically that paragraph is saying that the president may be led by his legal representative, not that the representative may testify on his behalf. So similarly, as the evidence leader would lead witnesses, then the president may be led by his representative. And then the other question of clarity related to whether the section 89 test was in the draft terms of reference. And then if members look at paragraphs 20 onwards, it says committee deliberations and decisions. And then 20.1, 20.2, and 20.3 does reflect on how the committee must consider the test that must be met in terms of section 89. So it is there, but we will wait members' comments as to whether it needs to be strengthened or not. Thank you.
Thanks very much, Suen. I want to then make a proposal that the members of the committee and political parties submit written comments to the committee secretary by Friday, the 10th of July 2026. Is that proposal accepted by this committee? Friday, the 10th of July 2026. Is there a mover?
So I move.
Honorable Maute seconds. Thank you. So that's agreed. So honorable members, written comments. We have heard what you had to say. Please put it in writing, and then we'll then consider the comments, and then we'll have the draft. That will get us closer to the final draft. We now move to the next item, which there was a lot of interest on the evidence leaders. Suen will also take us through that, just to say that the process, it's meant to be as transparent as possible, and all political parties are also going to participate in that process. Suen, please take us through the draft in the appointment of the evidence leaders.
Thank you, Chair. This is a much shorter document. This document was also circulated by Tim Nkosi. The title of it is Procedure to Procure the Services of an Evidence Leader and Assistant Evidence Leader to Assist the Impeachment Committee with the Section 89 inquiry into the removal of the President of the Republic of South Africa, His Excellency, President Ramaphosa. So with regard to the introduction and the background, these merely just state the process that we are embarking on. I will just turn to the legal framework in paragraph 4. In terms of the Financial Management of Parliament and Provincial Legislatures Act, provides that the Secretary to Parliament is the accounting officer of Parliament and is responsible for the effective, efficient, and economical and transparent use of parliamentary resources. The STP, acting in accordance with the FMPPLA and supply chain management regulations, may appoint external legal practitioners to provide non-routine legal services. Any appointment of an evidence leader must comply with the prescribed procurement principles, including fairness, transparency, competitiveness, and cost-effectiveness of both Parliament, as well as the policies and processes of the Solicitor General. The terms and conditions of the appointment of evidence leaders or assistant evidence leaders must be approved by the Solicitor General and be agreed to in writing with the STP and the appointed legal practitioners. That's merely just the legal framework, because if we do appoint advocates, there's a process to brief them. We would need an attorney, which for Parliament is the state attorney. So we just need to comply with these external and also our internal procurement processes. And then with regard to the role of the committee, in paragraph 7, the committee may request the appointment of an evidence leader to ensure an independence, competence, and credibility of its proceedings. The committee must identify the need for an evidence leader and assistant evidence leaders and nominate and recommend suitable qualified legal practitioners. And Chairperson, with regard to the requirements for evidence leaders or assistant evidence leaders, these are the guidelines that are proposed. The committee may consider requesting that the STP appoint one or more evidence leaders, and if necessary, one or more assistant evidence leaders. In this regard, the committee must consider its need for assistance with due regard to the scope, complexity, volume of material to be considered, and the available financial resources. In paragraph 11, these are the proposed requirements for an evidence leader. The evidence leader must be a senior legal practitioner with at least 15 years of experience and a proven track record. B, have expertise in constitutional law, administrative law, parliamentary law, and procedure and the law of evidence. Have experience in conducting trials, hearings, leading evidence in inquiries, or any similar related experience. Be willing and available to perform the services on the days and times agreed by the committee. Have the capacity to work long hours under pressure. Be a person with an even temperament and the ability to work in the public eye, and not have any real or perceived conflict of interest in respect of the matter. With regard to the assistant evidence leader, it is the same requirements except A, here if the committee chooses an assistant evidence leader, which in many instances is called a junior counsel to assist a senior counsel. Here we suggest that this legal practitioner have between 5 or 10 years experience and a proven track record, and the rest are the same requirements as with the evidence leader. Going to the process of appointment in paragraph 13, The chairperson must call on political parties represented in the committee to nominate legal practitioners with the role of evidence leader or assistant evidence leader in line with the respective criteria set out in paragraphs 11 and 12. The chairperson may specify the time and manner in which political parties must make their nominations. The Parliament's committee section must obtain the necessary political and financial authorization from the Speaker and the SDP for the appointment of evidence leaders and assistant evidence leaders. The Constitutional Legal Service must verify that the nominated legal practitioners meet the relevant criteria set out in paragraph 11 and 12 respectively. The legal services must submit the names of the nominated legal practitioners who meet the qualification criteria to the Office of the Solicitor General. The Solicitor General will indicate the legal practitioners who qualify in terms of their policies of the Solicitor General and are available to be briefed. The CLSO will submit the names to the chairperson of the committee for the committee's final recommendation on the appointment. The SDP, with the agreement of the Solicitor General, must enter into a written agreement with the evidence leaders and assistant evidence leaders, setting out the terms and conditions of their appointment. And then the last sentence is the Solicitor General will be requested to brief the recommended legal practitioners. Just to correct that last sentence, to say the Solicitor General will be requested to brief the recommended legal practitioner. Chairperson, that is the proposal on how the evidence leaders may be appointed.
Thank you very much, honorable members. So that is the proposal in terms of the appointment of the evidence leaders, that it be ourselves that first nominate. So we'll, in the same way that we dealt with the draft terms of reference, we are going to give each other time to nominate, and then the team will then work according to the criteria, bring back the list of, let's say, 3 names, and then we choose our preferred from there, and then they go and deal with the appointments thereof. But I will allow hands. Honorable Malema, I saw you first. Then let me see the hands.
I can start.
Start, Honorable Malema.
Oh,
the rest
thanks.
we can. When I nod to your hand, I will nod. So you can start, Honorable Malema.
No, thanks, Chair. I think that is a good process, Chair. We welcome. But I will suggest that we leave the appointment of assistant evidence leader to the evidence leader, because senior counsels ordinarily they've got their own preferred people to work with. That's what they call it, a legal team. Now, if you appoint someone for the SC and you find the legal strategy is not the same, their approach is not the same, and then we're going to be having too much time of 2 legal people fighting about how they want to move forward. So if it's a senior counsel with the years that you have put in the requirement here, you can trust that he will make the right decision in appointing the assistants, and therefore that's the only part where I think we should approach it differently. I mean, if they don't know each other, they're going to have to waste some time trying to know each other before they can even start our work, and it makes their work very difficult. And I will suggest that when we submit our inputs in the terms of reference, the same deadline work on submission of the name of a senior counsel, if we agree that the assistants will be appointed by the senior counsel. Thanks.
Thanks very much, Honorable Malema. Honorable Hlazo Webster.
Thank you very much, Chair. There seems to be a conflict between what the rules outline in terms of the appointment. They seem to refer to a facilitation by the secretary, and then this framework speaks about the political parties nominating. I think the question of clarity would be around which process supersedes the other. I think that's the primary question before there can be any other follow-ups. I think that clarity would be helpful. Thank you.
All right. Maybe just to clarify, so that if there's, remember the terms of reference have not been adopted yet. So in your input to the terms of reference, you might want to change that. So what we wanted to do was not to have the terms of reference first concluded before we appoint the evidence leader. So we are running the processes in parallel. So the one that takes precedence is this proposal, because it's in line with the rules of the National Assembly, the committee dealing with its own working arrangements. So the one that takes precedence insofar as the appointment of the evidence leader is the document that has just been presented now. So the other one, you will then give comments on it. Thanks very much. Honorable Khanyan.
Chairperson, thank you so much, and greetings to the members. I thought Webster was going to be adequately answered. Look, I agree with the broad thrust as presented, but also wanted to emphasize that there is one important point that is being made there, and reference is made to the Financial Management of Parliament and Provincial Legislature Act, that the Secretary to Parliament is the accounting. So what that provision means is that in terms of the architect of South African administrative law, there is none of us here who can appoint. It's not something that must be hidden. We must live here, all of us, with that understanding that anything outside of that will be desecration of that provision. So, and that's why I feel it's important that the question must be clarified. And from my layman's understanding would mean that whoever has a nomination that they may want to, they are allowed to make that nomination. For sure, there will be a process that will be outlined how members of the committee can make such nomination, and probably including members of the public who may want to nominate. And then following the mechanisms or processes that are outlined in law, the authorities that are empowered will make a consideration of the nominations. And maybe what we should be saying is what happens in the event where members of the committee are not happy? What recourse do they have? There was a point or reference was made to one of the advocates here by Honorable to say an appointment or the contracting of such an advocate doesn't present a conflict of interest. So I think there are important or fundamental considerations that have to be made. You need a lot of care and when the appointment is to be made. And to reconcile that, I may want to say that let's comply with the law, but very importantly, those that will be making the appointments, make sure that they act in the best interest. Thank you so much.
Thanks very much, Honorable Mahlatsi.
Thank you, Chairperson. Yeah, let me first agree with Honorable Malema by proposing that the evidence leader must be granted an opportunity to appoint the assistants. That is beyond an acquaintances, but it's to protect the chain of evidence in terms of operational methodology. Now, on point 11, on the requirements of evidence leader, there is where it says on F, not have any real or perceived conflict of interest in respect of the matter. However, the document does not clearly define or disclose the disclosure framework. And then there is no independent vetting methodology that is clearly specified. I'm saying this because Section 209 gives provision for establishment of 3 intelligence bodies, the crime intelligence under South African Police Service, the defense intelligence under the South African Defense Force, and then the State Security Agency. Are you going to conduct vetting on the recommended evidence leaders and their staff? And which body between the 3 you're going to appoint? I'm warning the chairperson to remember that the State Security Agency is part of budget for vote 1 under presidency. And then there's also issue of the operational gaps that I've identified in terms of no timeline, the framework in terms of evidence collection. How long are we going to wait for the evidence leader to complete his work? Just to tap on the earlier, you introduced interns, you introduced very big stuff. I propose that they must be vetted. But while thinking about it, also think about which body is going to vet them to avoid the conflict of interest. Chairperson, I submit.
Thanks very much, Honorable Daniels. Thank you, Chairperson.
Chairperson, I just want to check. The evidence leaders, will the evidence leaders, will the mandate of them be limited to leading evidence relevant to the charges that are formulated, or will they rather conduct an investigation at large? Those terms of references are important. Now, having listened to how the evidence leaders are going to be appointed, I think it is important that I state our position that we would have rather wanted the process to run through the Secretary to Parliament, the Solicitor General, under the governing legislation, so that it can be done on a competitive and conflict-free basis. It will guard against, Chairperson, it will guard against a single faction control of the evidence function, by what I've heard here before us. The rules that speaks to the evidence leaders must guard against them being turned into investigators, commissioned to gather new material beyond the referred matter. Let's not forget that the matter has been referred by the highest court. So we must be sensitive to how the evidence leaders, the modalities of the procedures. Because we cannot at large to investigate beyond what was referred to us. That is my point. Because against the background, as the earlier presentation of Section 89.1, it's not to open fresh self-directed investigations of its own design. We are limited to what has been referred to us by the highest court. Chairperson, in conclusion, I want clarity on whether the processes for the appointment of the evidence leaders, if it is that it can be considered through the aforementioned by me, that process, as opposed to leaving it open to us as members of this committee and individual parties to make proposals. Thank you, Chairperson.
Thank you very much, Honorable Hlophe.
Chairperson, I beg to differ with Honorable Daniels. The attitude of the Speaker is very clear. We may not refer this back to the Speaker's office. We should do our own appointment here, as already stated. But I want to remind this House about the committees that are sitting currently here. One is the Madlanga Commission. Before Madlanga Commission, we have Advocate Matthew Chaskals. And the other committee that sat recently was the Ad Hoc Committee here in Parliament, and the evidence leader was Norman Arendse. If you look at the two and compare the two, their roles were totally different, or they perceived their roles in a totally different way. Advocate Chaskals is more robust, he's aggressive, he's objective at the same time. But Arendse was more laid back, more passive in the Ad Hoc Committee. The direct question that I want to ask is, we have to agree on what we are looking for. Are we looking for another Norman Arendse, or are we looking for a Matthew Chaskals? Thank you.
Honorable Mpapane.
Thank you very much, Honorable Chairperson. On this matter of the evidence leader, I want to support that as political parties, we are given the opportunity to make proposals to the Secretariat, then also to We are making proposals to the Secretariat. After that, I believe this committee will come up with one name, which will be processed through the procurement processes of Parliament. Then on the deputy, assistant, I'm used to deputies. On the assistant evidence leader, Honorable Chairperson, I don't know, because lawyers, usually they don't agree. You can attest to that. Sometimes they don't agree. So choosing an assistant for the evidence leader, I would support that maybe it will be appropriate for the evidence leader to get someone who will be able to work with him so that the work of this committee is not, him or her. Yes, Akira, we are used to the male lawyers. Yeah. So that would be my submission. Then on the issue of vetting, if we say vetting must happen to the staff, it will be unfair because Tina, we will not be vetted. Are we saying that we want to be vetted? You cannot vet staff members while Tina, we are not vetted as members of Parliament. What are we saying exactly? I just want to understand that. Thank you very much.
Honorable Zingula.
Chair, we need to have direction on the question of the real or perceived conflict of interest when it comes to the evidence leaders. As we speak now, we have the draft terms of reference drafted by someone who was in court, in the Constitutional Court in the case and against the application that led us to where we are now. So on the question of the conflict of interest and perceived conflict of interest, what does that look like? If, let's say, a party nominates someone who was part of the litigation back in 2024 or part of the litigation now, whether it is the interdict or the review application, is that viewed as a conflict of interest? Because I think we need to understand the parameters of the real or perceived conflict of interest, particularly how your assertion when answering the issue of Breitenbach was that there is no SC, Breitenbach SC, that there is no conflict of interest. That is the first issue that I wanted to raise. The second issue, can we then presume if the deadline is on the 10th of July, the committee will sit the following week, given the fact that there is we have quite some time that we are not going to be meeting, and from the time the Concord gave the judgment on the 8th of May, we may need to speed up the process and ensure that we do not waste more time. Thank you, Chair.
Thank you, Honorable Mashaul.
Thank you very much, Chairperson. I think the line to allow political parties to submit the names of evidence leader will be the correct one, because at the time you submit to the National Assembly, they will deal with payment. We are not going to be involved. So it doesn't take away the fact that we are not involved in paying and involved in money. So it is a correct approach. I just want to add, and it's not compulsory, that in the time period you would have given us, political parties meet to lobby each other, even those who do not agree, to narrow down the names when we come here, so that we don't have 31 names. We have a reasonable number of names that we're going to ventilate on and agree, so that we make our work easy. There's just one point that I am concerned about, and maybe members will give direction on how we can deal with it. Honorable Ngobeni, and I think I was told that the EFF raised it, I was not here, that now that the first item of the agenda, we have given it some time so that we submit. And then in that terms of reference that we must ventilate, there's also the criteria of the evidence leader, which we must submit on what will be the criteria of the submission of the evidence leader. The one problem I have is the concurrence, Honorable Malema, of the process of submission of the parties on that one and this one at the same time, because my belief is that you must first conclude with the criteria and then appoint after the evidence leader. I would think that let's reconcile it by adding some few days on the appointment of the evidence leader when we have agreed on the criteria that is inside the terms of reference. It's my suggestion, honorable members. And just want to agree that it may defy logic that we appoint the assistant to the evidence leader. Like it was said, may take time for them to agree on certain things. We have seen in the Madlanga Commission, up until today, we don't know why Advocate Terry left. And if there was nobody else, they would have to start again the process of procurement. We don't want to go there. So let's not have people who don't know each other. And I don't think we'll lose anything if we allow the evidence leader to come with the assistant. So I just want us to reconcile the point that I'm making. Thank you very much.
Thanks very much. So I have 5 other speakers that need to give an input, and then we will then move from there. will be Honorable Makwela, then followed by Honorable Hlazo, then Honorable Mtambi, Mahlatsi, and then Litchfield will close, and then Honorable Trolip. I'll make a ruling before Honorable Trolip. Thanks.
Thank you.
It's Makwela first.
I wanted to get first before. The two colleagues that you have mentioned they've spoken before, you are giving them the second bite, Matlasi, and they spoke on this. I see you are mentioning their names again, whereas some of us raised it.
They say it's okay. Honorable Makwela.
Thank you, Chair. I think let me align myself with the colleagues that have supported the process that needs to be followed in the appointment of the evidence leader and the assistant. Well, I want to get into the aspect of the vetting process, given the sensitivity and the gravity of the matters that we are dealing with. The Honorable Dr. Mahlasi rightfully supports that the evidence leader must be taken through a process that would support vetting. But then he says that it should not be done by the organs of state that are currently established because they reside within the presidency. Yes, you can clarify me if I've captured you incorrectly.
No, you will come back. Please proceed with the point. Please proceed.
Okay, thank you, Chairperson. If I've captured him incorrectly, he'll clarify. But I want to align myself with supporting the view that says the evidence leader must be taken through a process that is going to vet so that we are able to understand that the person that we are appointing will be in a position to conduct the inquiry with the sensitivity of these matters and the credibility that warrants the processes that we are undertaking. That will be my submission, Chair.
Honorable Litchfield.
Thank you, Chair. I think I'm aligning myself also with the vetting. And I think I also align myself with the view that because of that budget vote that sits in the precedence, it is not said they shouldn't be vetted by state organs. But I mean, we have two other intelligence agencies, whether the police or the defense one can do it, but not the state one, if I understood the doctor well. And I want to support. And just in terms of what the Honorable asked, but she has left the room. I think for political parties, our political affiliation is already disclosed. I mean, I sit here as an MK member, but in terms of support, we don't know where their allegiance is, and their allegiance might as well be with the ruling party, and their allegiance might as well be with the speaker. I think, which is how this evident, which is how the necessity of vetting then springs up. So I'm just answering because she left. She said, "Are we willing to be vetted?" While we are
Honorable Mahlaule.
Yeah, you are interrupting me, and I'm being gracious with you because if I start interrupting back, it won't be nice.
No, Honorable.
So,
continue, Honorable.
Yeah. So
Honorable Mahlaule.
I was saying they must make an example about MK.
Honorable Mahlaule.
Given the platform, we are doing it because it's me. We can tussle this and go forward.
All right. Oh,
deal with your attitude.
No, Honorable Litchfield.
Thank you. So I think that matter arises because of that. While we are willing to be vetted, but I'm saying our political allegiance is already disclosed because that matter arises from that perspective. Because we have had a lot of questions at that National Assembly where we are asking the cabinet, is the staff attending ANC political lecture? So there is that mistrust that lies there. So which is how the question of the vetting comes up. And from MKP, that's the notion from which we are supporting it. And we are saying to equate that to saying, do we need to be vetted? But our political allegiance is already disclosed, although we are not hiding away from being vetted too.
Honorable Mtambi.
Thank you, Chair. This procedure, it's also read with the proposed Article 8 of the Terms of Reference. The issues that Honorable Klaso was also raising, because these two documents are interlinked. If you read 8.11 and 8.12, it specifies who should be the chief evidence leader and 8.12, and then you read it with 11. 11 and 12, they further expand more than what is written in the Terms of Reference. And then the other issue that I like about it, if you read paragraph 18 of the procedure, it says that the chief legal state officer will submit the names to the chairperson of the committee for the committee's final recommendation on appointment. So at least it outlined the process. What I'm trying to propose, Chair, is that this must jointly go together because it has got an impact on the terms of reference. So there has to be some sort of an alignment so that our terms of reference should not be completely different from what is provided for. So I should think that's the point I'm trying to bring, is to say on that time frame that you are giving, include this, because this talks to actual paragraph 8. Thanks for the opportunity.
Thanks very much. Before I go to the second round, Honorable, just to say, I said I'll give Honorable Trolip a chance. And because this committee, all political parties are represented in the committee. So except for the GOOD and PAC, we're going to use, in terms of Rule 156, the participation of alternates in the committee, so that there was an issue of time and so forth. For this meeting, I'll accept Honorable Trolip to give his input. But going forward, when the main member is in the committee, when the main member is in the committee, the alternate will not participate in the committee. Just that's the ruling that I'm making from the chair. Is it on my ruling?
No, Chair. I just want to apologize to Honorable Lichfit Chabalala. It was meant to be a joke, and it may have landed otherwise. My apologies.
All right, apology noted. I'll note. Is that a point of order?
Just a quick one, Chair. So are you proposing that for this occasion, Honourable Trollope, in future, that's the guidance? Yeah, I don't have a problem if it's so just for now.
Yeah, so I'm saying I'll allow Honourable Trollope to contribute because the main member is in the room. But going forward, when the main member is in the room, the alternate will not participate as per Rule 156 of the Rules of the National Assembly. Honourable Trollope.
Thank you, Chair. Thanks for the question. I appreciate it. I want to delay place on record that will not any inclination you have. We are an independent panel. Independence is shown in this matter regarding and we cannot any to out.
Thanks very much. I see second hands. So just to say that the proposal on both sides, so that we don't belabor this point, and I'll put it to the decision of the committee because we can move around in circles, that the committee is going to recommend the evidence leader. The supply chain processes, the contracting is done by Parliament. But the committee, as per the proposal, if you read the 8, it says the committee recommends. So we give the name and then the Parliament staff, State Attorney, Solicitor General deal with their processes there. But the name is given by this committee. So that's what the proposal in front of you says. Honourable Mane.
No, thank you, Chair. I think your summary speaks to one point I wanted to speak to, but I had 2 points to add so that when you also summarize, you can come back to that point. The point relates to the vetting, because we're moving back and forth on that part, that indeed, as a member of the committee, as I speak, is to agree to the vetting as it relates to the evidence leader. But it also speaks to the agency at which we would have wanted things to happen. You can imagine the introductions that we've made of the staff and waiting for each one of them being vetted, Chair. It will not help the committee in that way. The last point to make is it's really on the part about the timeframes. Having agreed on the terms of reference submissions, because this point has been raised, I just thought I should also add to it, as seconding it. It may be something you want to apply your mind on, that if the evidence leader's requirements and everything else is within the terms of reference, you may want to give that space, but with few days, to be able to get the appointment that's linked to the terms of reference of the committee. I'm sure the last point you are still going to respond to it, which talked about perceived or real conflict of interest. I'm raising this also because if we see it in that way, the parties involved here may also be seen to have been in a particular legal action, right? So I'm saying it may not be also a matter that gets resolved now, but as part of clarifying the terms of reference, at least this matter be quite clear so that we don't come back to discuss it. Thanks, Chair.
Thanks. Honourable Hlazo, then Honourable Mahlatsi, Honourable Mahlaule, Honourable Malema. 1 minute, because you're coming for the second.
I'm okay now, Chair. I'm covered. Thank you.
All right. Honourable Mahlatsi, 1 minute.
Thank you, Chairperson. I just want to clarify the matter of the three bodies to Honourable Member. I said we have the State Security Agency, which falls under Vote 1, Presidency, and we must avoid that one. We still have the South African Police Service, Crime Intelligence, and we still have the Defence Intelligence under SNTF. We choose between the two. Personally, I propose the Defence Intelligence because your general opportunity, I'm not finished. And the issue of vetting staff, you were supposed to clearly define the duties of the key performance areas of the staff so that we know that they'll have access to sensitive information. Because the MIS documents state clearly in Chapter 4 that once that information is protected, it will be known as classified information. We have young kids who come from Stellenbosch who are going to be part of this process, who are not members. And to answer that question, it will find it in Section 2, Subsection 1A and B on the National Intelligence Strategic Act. Chairperson, I submit.
Thank you. Honourable Malema, 1 minute.
Chair, I can tell you now, you're not going to get any senior counsel who's going to agree to be vetted. You're not going to get it. The reason they're called senior counsel is because they are beyond reproach. They are officers of the court. If you want to vet a senior counsel, it's the same as wanting to vet a judge. And they are not asking for a job. You go to them or come here, come and lead our evidence, but we're going to vet you. Who will want to subject himself to such a thing? So you are not going to, the senior counsel, the evidence leader comes, he takes an oath here, and he knows once he's taken an oath, amongst other things, it will be that you are not conflicted and so on and so forth. And then he commits to that. If he engages in anything, if he lies that he's not conflicted and it comes out down the way, the professional body will deal with that. He will be dealt with professional bodies that regulate them. But to get a senior counsel that agrees to be vetted, I can guarantee you it's not going to happen. So that's number one. Number two, which is the last one. No, the last one. If we are going to extend the names with more, I agree with the spirit, but my problem is that we don't have time. So we'll rather say that the way we've synchronized the items now, that the terms of reference we finalize with them, and if we want, take a little bit of break and then come to the names. Because you can't postpone it with the 5 days again. Because once we agree on the thing, we know that we're going to appoint the evidence leaders that must start the work.
Thank you.
So we can't have meetings, but also, Chair, we're going to start struggling with the quorum if we keep this thing postponed, because we're going into the elections. So the sooner we deal with what we have to deal with and leave the rest to the evidence leaders to do, and then call us back, the better. So I will not agree that we postpone for too long.
Thank you, Chairperson. I still think we need to reconcile the two. I don't know how we're going to do it. I think it's important. But I have one technical question that I want to ask around vetting. So here is a senior counsel. Let's assume the one agrees with vet. There's this thing in South Africa where they say your appointment is pending the vetting results. Are we going to wait for the results, or what will happen? That's my question around vetting, because we must know what is going to happen now.
All right.
But you're not as patient as you
No,
were.
I said 1 minute.
Yeah, but you did different to Honorable Malema. Chair, it's now going to be us who are saying you are not impartial. If you do the
Wrap up, Honorable Malema.
Thank you.
Honorable Dagmo is the final one. Then we're going to take a decision as a committee.
Very much, Chair. Chair, we have a document in front of us which outlines the procedure. And I think it's correct that the committee, because we want to work together, we want this to be credible, that ultimately we will have the choice. But I want to just clarify with you that, for instance, in terms of 18, the CLSO will submit the above names to the chairperson of the committee for final recommendation. So all those other procedures still have to be followed. Can I just get clarity? Because we're commenting on a document in front of us. We want the whole committee to agree, but you have to have those other processes. So are we agreeing to this document? That's what I'd like to.
All right. Thanks very much. And thanks for the input. So what I wanted in terms of the thinking was so that we don't delay. We need to start moving with speed. The appointment of the evidence leaders, it's not dependent on the finalization of the terms of reference. So this document, if we accept this document and the process, and I'm going to put few decisions to the committee now. If we accept those decisions, then the process of appointing the evidence leaders can then start so that the two run in parallel. We don't have, because otherwise, if we were to put a dependency on the terms of reference, going to submit your written comments, the team will have to go back, synthesize the comments, do the draft. We have a meeting, adopt the draft, and then go into the process of appointment. So we are running this, want to run this together. So I'm going to ask the committee to make some decisions now, insofar as the evidence leaders are concerned, so that we are able to take. I know that you want a response to the question on the conflict of interest. To have a response in terms of the conflict of interest and what should be considered in that regard.
Chairperson, that provision is written quite widely. It says the evidence leader must not have a real or perceived conflict of interest in respect of the matter. So that will deal with anything that will compromise the person's ability to serve the best interest of the committee, and that will include whether they represented parties or the president in any matter related to the issue at hand. But also just to remind members that the rules of the legal profession require them to declare any conflict. So it's just normal when the Solicitor General approaches someone, they would upfront say, unfortunately, I cannot take this matter because I acted for president, I acted for this party. So if they don't do that, then they are in breach of the rules of the profession. So there is that added safeguard that will be checked with the Solicitor General.
So in short, any person that has dealt with this matter shouldn't be considered. Any person that has dealt with this matter, either through the Concord, the High Court, the Public Protector, SARS, and everyone else who has dealt with this matter, shouldn't be considered. So as you I come to the decision. So the first decision that I would like the committee to make, clarity, Matla?
I asked the question on the vet.
It's part of the decisions that we are going to take as a committee. So the first decision that I would like this committee to agree to is that ourselves as a committee are going to recommend the evidence leader for Parliament to appoint. The political parties are going to make a nomination, and the committee recommends. Is there acceptance of that?
Just a clarification I seek. That's the principle we established, but are we comfortable with the process of appointment as in this document? It amounts to the same thing that the committee. So we all agree with that because that's in the document. So are we agreeing to, because there's a process. We must clarify that.
All right. You want me to put the document first? But
No, Chair, can I just clarify? In the document which has been presented, it says process of appointment. It's got 13 right down to the issue of 20. And for instance, there's the CLSO involved. Firstly, you call for nominations from parties. We agree, we put those, and then they finalize. So the issue is what you're proposing does not seem to contradict what's in this document. So that's what's in front of us. So I'm just trying to clarify from you as the chair, are you asking us to approve the process in the document? Because that is the committee. It's clarified here that the committee does the final appointment.
Yes, that's what I'm just taking it point by point so that everyone understands what's going to happen, Honorable Dagmo. Because there was an input by Honorable Daniels to the effect that it should be the secretary that appoints the evidence leader. So now there are two views. One is that the committee appoints, the other one is that recommends. The committee recommends. The other one is that it be the the secretary that does that. So that's the decision that I'm putting to the committee. Honorable Mauto.
Thank you, Chair. We agree that the committee recommends and Parliament can deal with procurement processes after that. But the name should come from this committee. Thank you, Chair.
Thank you very much. Is there anyone that's against that proposal? Honorable Daniels.
Chairperson, it is quite evident that by the submissions made that the majority is in favor of going the route that was recommended. So there's no point in opposing it or going against it. I'll accept. Thank you.
All right, thank you very much. So the original document had proposed that the committee also appoints assistant evidence leaders. The input that was given by this meeting was that be left to the evidence leaders to appoint the assistant evidence leaders. Is that agreed by the committee? Is there anyone that disagrees?
No, there's no one.
All right, thank you very much. There was a submission that which was not part of the document, that the evidence leaders needs to be vetted, né? And there were conflicting views, and the views that were expressed was that it can lead to time delays and that we might not get senior counsels to agree to do this work. So I'm putting it because it's a proposal that was made. Is there anyone who supports the vetting of the evidence leaders? All right, it's Honorable Litchfield, Honorable Mashatsi, Honorable Adams. All right, there are 3 members who support. Members that don't support the vetting of the evidence leaders, the vetting of the evidence leaders is thus not supported. So those are the decisions insofar as the evidence leaders concerned. So there was the other issue that was tabled in the discussion, but also I referred to it in terms of the appointment of other investigators that will include forensic investigators, forex, data analysts, and other investigators that the evidence might be needed. Is there principled agreement in terms of the committee being assisted by other investigators, including but not limited to forensic, forex, and other investigators that will help the committee get to the bottom of the matter?
Just a minor correction. The letter says forensic investigator and exchange control expert, not forex.
Not forex. Exchange control.
Expert, yes, Chair. Thank you.
Including that, but not limited. Exchange control, forensic, data. I think I had a request for data. Can we agree in principle, but that the process will happen after the evidence leader is appointed? Can we agree in principle? So it's agreed to in principle. Thank you very much, honorable members.
I just wanted to confirm something, that proposal as presented.
Yes, thank you very much. I'm coming to the honorable Mashao.
Forgive me, Chair. How did you end reconciling what I had raised of finishing the... Okay, I may have missed it. My apologies.
I did deal with it.
If you addressed it, it's okay.
All right, thanks. Can we agree on the deadline to submit the nominees as the 10th of July 2026? Can we agree to that? Political parties submit your nominees, and then there will be that process that will happen in the background. A shortlist will be presented based on availability and people willing to take the case and all the criteria that's there, and then the committee will make the final recommendation. Can it be minuted the 10th of July 2026? Thank you. All right, thank you very much. We're now moving to the last item, which is the adoption of minutes. The minutes, if you can, committee secretary, if you can take us through the minutes of the 1st of June just quickly, and the minutes and then we'll move and adopt, and then move to the minutes of the 18th.
Thank you. Thank you, Chairperson. Thank you, honorable members. Once again, Chairperson, the minutes of the 1st of June that had one agenda item, which was the election of the Chairperson. Melissa will be flighting them. It starts with the first page that talks to the attendance of members, and that also the second page. And then from that, Chair, just to indicate the secretary opened the meeting and facilitated the appointment process. And Chairperson, there was a briefing that was made by Mr. Kaso, a very short briefing in relation to the participation of Dr. Hlophe. And then Chairperson, we ran the process of electing the Chairperson, which led to you being elected the Chairperson of the committee. And Chair, that would be the minutes of the 1st of June. Thank you very much.
Can I have a move of the minutes? Honorable Khadebe moves, seconder. Honorable Bredenbach.
Chairperson, thank you very much. We would now table the
minutes of the 18th.
The minutes of the 18th of June, the meeting that was called last week, to receive a briefing by the Constitutional and Legal Services Office on the President's Court interactive application. We had great attendance from the members, which is covered in the first 2 pages of the minutes, and then Chairperson from page 3, they're welcoming, the apologies, the briefing that was done, and in the last page, Chairperson, it will be the resolutions of the committee, which are very straightforward. And Chairperson, the minutes were shared with all them.
Any move of the minutes? Honorable Swat. Any seconder? Honorable Papa, any seconds? Honorable members, ladies and gentlemen, this concludes our meeting. Thank you very much. The house is adjourned and lunch is served. Lunch is served, honorable members, just next door.